month. So shall I give it?
Yes, yes. Hand over the slip. It will appear next month. Hearing.
My lord,
Yes.
several matters we mentioned prior to the vacation. Your lordship directed also for listing.
Motion.
No, hearing matters. 4 matters which were
Come on,
as
sit
per
down.
the direction of the division bench, but they have not been listed. There also the honorable division bench had directed that advancement of the hearing. So your
Mention
lordship,
that at the end of this month, before the monthly list is prepared, this will not come up in the list.
we mentioned.
You also mentioned this once again at the end of this, Mr. It's better you take back the slip and mention at the end of the month. So,
Okay.
so it will be listed actually. Otherwise, it may be missed out.
So those matters also I mentioned.
Yes, mentioned together at the end of the month. I'll allow all of it.
Great.
Yes, sir.
Upon notice, I am mentioning on old content. Old content.
Contempt matters. You know, contempt matters. Yes.
Content matter.
My lord, may I be
Just a
permitted
minute.
to?
Yes, sir. Hand over the contempt matter slips.
Notice.
আমার সব determination আছে contempt.
I will notice
কি আছে? হ্যাঁ। নিয়ে যাও। নিয়ে যাও, কিচ্ছু হবে না, নিয়ে যাও। নিয়ে যাও, নিয়ে যাও। হ্যাঁ, হ্যাঁ, নিয়ে যান। There is no notice. নিয়ে যাও, ফেলে রেখেছো কেন?
First time it is coming because that matter was dismissed for default. Restoration has been the application has been filed. No one appear contempt matter, but new matter, new contempt, old matter. Yes, new contempt.
New. New.
My
My lord, may I be permitted to mention?
I have already served the notice, my lord. Because my lord, contempt proceedings, my lord, your lordship, date has been fixed. But I am praying for my lord. Yes, yes. I have already served notice upon the other side on 14th, my lord. Your lordship fixed the matter for appearance, my lord. And subpoena has been issued, my lord. My lord, I am ready with draft, my lord. Can it be, my lord, taken up on first?
My lord, may I be permitted to mention a hearing matter? My lord had mentioned this matter before the vacation. My lord had directed me to. No, my lord, it is not appearing. My lord had directed me to mention after the vacation. So today is the first day, my lord. My lord, I have understood. My lord had directed what directed Mr. Sharaf. But subject to my lord's kind consideration, may I be permitted to hand over the slip, my lord, and I will take up the issue with my lord's officers, my lord. Yes, yes, my lord. I bow down to your lordship. Next month, yes, I will. My lord, still I'm giving the slip, my lord. I will pursue the matter.
My lord, I had mentioned this matter before the vacation. The lordship was directed to come after the vacation. My lord, covered matter, expiry of e-waybill, your lordship's own judgment, I am covered by that, my lord.
What is the matter?
My lord, expiry of e-waybill, my lord, the direction was given for filing affidavits in 2022, my lord.
Ordinary it will appear. You have to mention at the end of the month. Hearing matters don't mention today. It will not be taken out. So you understand this month's list has been prepared. Let us see how we proceed in this month's list. And next month I'll take up these matters.
My lord, I'll mention at the end of it.
Yes, I'll take up.
My lordship,
Lordship, my lordship, with your kind permission, lordship, this is an application for review, lordship, and yes, lordship, review of second appeal, lordship, that has been already disposed of. Review of second appeal, lordship. Second appeal has already been dismissed, and then review application in connection with. No, lordship, no. Second, it is second appeal review application, lordship. That is.
Decide that. Second appeal. Are you sure?
Yes, lordship.
I have never had determination of a second appeal.
Second appeal, lordship, that has been disposed of. Then review application has been filed, lordship.
I took the determination first of the day and I passing the order.
Applications. Order. That has been already disposed of. Then Honorable Justice Siddhartha Rai Choudhury, and the matter was later on. The matter was heard before this Lordship Justice Ravi Krishan Kapoor, Lordship, on February. This is that is a review application, Lordship. হ্যাঁ notice of that
May I mention a matter, two matters, one mention on market is yes. Mentioning matters for recording of names in the order sheet matter. Final order. Yes, minor, yes, ma'am. Final order. This was. It has been already disposed of. It can be recorded. No, it is not recorded by them. The advocate on reverse name is not recorded. No, she was present during the hearing. Sir, it is already said. Information and what the limits of getting it recorded down. You have given that slip when the matter was taken up. It was written, but somehow it was taken not recorded. Is it so relevant? You have a material bearing in your matter, then I will direct this matter to be listed. Otherwise, it doesn't have a material bearing. It's not unnecessarily flood up these matters with these matters. Does it have a material bearing? Tell me. Actually, my name is dependent on something else. That unless our name is recorded, it will not be denied of a basis. Yes. You ought to have indicated this when the matter was taken up, that her name should be recorded.
Your lordship, your lordship mentioning for inclusion for contempt matters.
my lordship
Where is your notice?
Mentioning slip is.
No, mentioning slip will not.
Notice.
Dispose of matter, where is the notice?
Notice.
Ready? She mentioning a matter, dispose of matter without a notice. What is this going?
Notice.
My lord,
Permitted to mention one contempt application arising out of. Yes, lordship of this determination arising out of the order passed by Honorable Justice Abhijit Gangopadhyay as lordship delivered.
my lord, may I have your lordship? May I have your lordship's kind leave to mention a review matter for inclusion, my lord? By his lordship, my lord, Honorable Justice Subhashis Dasgupta, as his lordship then was, my lord. My lord, one thing more I would indicate to your lordship, my lord, this is in respect of a civil revisional application which was disposed of without issuing notice, summarily disposed of, my lord. Therefore, my lord, notice at this stage, my lord, has not been served because this has not been admitted, my lord, at the first instance. This civil revision was not admitted, my lord. It was summarily disposed of, my lord. Let Shravan come back.
Yes.
I'm grateful.
Lordship, may I permitted to mention this matter for inclusion. This is an application for restoration of the first appeal. First appeal. This is a restoration application, my lordship.
Determination matter. Yes.
Lordship, may I be permitted to mention, Lordship, restoration of a writ petition, Lordship, matter has already mentioned prior to the vacation, Lordship, but it is not appearing in your Lordship.
Yes, Mr. Dr.
My lord, this is a restoration application. The contempt app, it was a contempt application. It was dismissed on default before Honorable Justice Jyotirmoy Bhattacharya. Grateful, my lord.
Yes, my lord. No, item number 317, my lord, there is a connected application in the item number 317 of today's list, my lord, monthly list, my lord. This is under the heading hearing, my lord, but the connected application is required to be heard, my lord, because it is against the recovery notice they have issued for pay. I have filed this application separately for paying interim. My lord, separately, my lord, then, my lord, I have to give a hand over the slip, my lord, otherwise it will not appear, my lord, since it is under the heading hearing, my lord.
When the hearing matter reaches, I'll take up your.
Yes, I'm grateful, my lord.
Your lordship, WPA number 18102 of 2020. Your Lordship, may I be permitted to mention a matter? Your Lordship, WPA number 18102 of 2023. Your Lordship, this matter was last taken up on August 8, 2023. Direction was given on both the parties to exchange affidavits, Your Lordship. Affidavits have been exchanged in this matter. Your Lordship, I'm praying for the matter to be included in the list.
Justice, my Lord Justice, Lucas Bannett. Today, my Lord, today.
Lord, may I mention, my Lord, this is that FCI pension matter, my Lord. My Lord, had passed an FCI pension matter, my Lord. Mr. Chattopadhyay, Kamal Chattopadhyay appearing the other side, my Lord. My Lord, the appeal has been disposed of, my Lord, with the request that my Lord should hear the entire matter, my Lord, and pass an order. That is the only request. My Lord's order has not been interfered with, but my Lord, the central government has not given a report till date.
Where is your affidavit?
My Lord, he is not the, my Lord. I have served notice, my Lord. No, I have served. No one is appearing.
Lordship, I'm for
My Lord, he is not there, my Lord. He's not the other side. It can be kept as to be mentioned, my Lord, so that this direction can be at least. Only to the only point, my Lord. And they have given nothing, my Lord. And my Lord, they have given a report by a one-page report, my Lord. It says that this was extended to them. It was extended to the central government employees, my Lord. This circular. They have given that report, but in affidavit form, they have not served, my Lord. That is the only determination is pending, my Lord. I have given notice, my Lord. It's here. Parted, madam, any day. Okay, my Lord. It may be included in the list, my Lord, because the change in determination has gone out, my Lord.
Lordship, these three matters are GST refund matters pending before my Lordship's bench. And the last instruction was the exchange of affidavit. That was 2 years ago, Your Lordship. Now the department has sent us notices for asking for a stay petition, stay order, or otherwise they will go for realization, Lordship. Lordship, affidavits have not been exchanged, Your Lordship. And the department has sent notices.
Yes, Jalpi.
হ্যাঁ জলপাইগুড়ি দিয়েছে এটা কোথায় লিস্টটা কোথায় আছে জলপাইগুড়ি বেটার 10:30 AM item number 1 কেউ আছে Lord, I am appealing for the petition, my Lord. Jalpaiguri Circuit Bench, my Lord.
Where are the original records in these two matters? Where is Mr. Mojumdar?
My Lord. I am intimating him, my Lord. I'm like kindly fix that, my Lord. 2, my Lord, I am intimating.
Very well, I'll take up at 2. I need the original records. Without original records, I cannot decide.
Yes, my Lord. I am intimating him, my Lord.
As far as this matter is concerned, the first matter which I've already disposed of in the Jalpaiguri circuit, there are
Yes,
certain
Lord.
things in this matter.
Yes, my Lord.
That's the reason why I had retained these matters. Where is the original record?
I am for the petition, my Lord. The Mojumdar is appealing for the Union of India, my Lord. I am intimating him, my Lord.
2 p.m. at 2 p.m.
Yes, my Lord. Yes, my Lord.
Now go. Both the matters.
Monthly list would- Dago. Actor, monthly list for judgment 10:30 AM, item number 1.
Mr. Niyogi, the bipartite settlement does not provide for continuance of proceedings beyond the date of superannuation. I've taken into consideration that aspect. That was the reason. Initially, my view was a little different. Anyway, the judgment was dictated initially in court. Thereafter, you remember.
Only that point.
That was the only point involved.
Yes.
So I've held that the disciplinary authority, having failed to return a tentative findings and having given his positive findings as regards charge number 1 while differing with the report of the inquiry officer, the inquiry proceeding stands vitiated from that stage. However, taking into consideration the fact that there is no scope to continue with the inquiry any further, I did not remand the matter back. I have also taken note of the objection raised by them and that the charges numbers 2 and 3 were proved and there was no question of difference. To that, I have said that the final order passed by the disciplinary authority was a composite order and therefore it's not possible to differentiate. And insofar as the issue of sending the matter to the tribunal is concerned, I have considered that. I have held that although liberty was granted, that at the time of final hearing this matter, this issue shall be taken up for consideration. However, taking into consideration the fact that there is a procedure, I'll read it out for you. Admittedly, the writ petition concerns violation of principles of natural justice as also procedural irregularity, which has the effect of vitiating the inquiry proceeding. Such is the defect that the same could not have been rectified even by the tribunal. Although before the tribunal, the respondent bank could have got an opportunity to establish the charge afresh. However, by reason of the petitioner having already reached the age of superannuation, I do not find any reason to relegate the parties to the tribunal at this stage. For the same and identical reason, the option of remanding the matter to the respondent bank for them to conclude the same from the stage when the same was vitiated is also not possible. For reasons more fully indicated here and above, the objection raised by the respondents fail. Set aside the order of punishment, and as a sequel thereto, the appellate authorities order and the disciplinary authorities also order both stand set aside. I've also said at the same time, taking into consideration the fact that the petitioner has not discharged any functions with the respondent bank subsequent to passing of the final order dated 12th February 2008, the petitioner shall not be entitled to any actual benefit, but shall only be entitled to notional benefits and other consequential reliefs with the disposed of.
Well, can you fix certain time to be his shares retired?
No.
Fix certain time, man. Can you fix certain time to
What?
For giving the consequential benefit, man. Giving some time, man.
It will be given.
Otherwise, he has retired in 2008, my lord. Kindly consider.
When did he retire?
When a superannuation of 2018.
Say so.
Say so.
Why are you saying 8? 2008 is the order of punishment, Mr. New. Yes. No further direction is necessary.
Well,
As retired in 18, he'll get it.
Well, only California.
If they want to test it out, let them test it out.
That's our thing. Well, kindly pass such orders so that I can get some benefit.
Yes, yes, I've said so.
My lord.
Notional benefits,
My lord.
consequentially everything, but actual benefits you will not get. Means the salary you will not get. You did not work.
My lord. I'm grateful, Judge. I'm grateful.
To be mentioned, item number 2.
On behalf of the petitioner in this matter, Your Lordship, Learned Senior Mr. Bishwas is there in this matter. He is on his way, Your Lordship, I am praying. He is on his way, Your Lordship, I am praying for short path over, Your Lordship. He's coming from Kotum number 10, Your Lordship. Your Lordship, I am praying for short Passover, Your Lordship. Please kindly grant one purpose.
This matter has already been assigned for this court. In view of the above, the respondents are not present. In view of the above, find further opportunities to appear. Further opportunity parties to present their case, let this matter stand adjourned and appear under the heading hearing in the month register of July 2020.
Your Lordship, I am praying for short Passover. Kindly grant one Passover, Your Lordship.
Assigned, sir. What Passover I will give you?
He is on his way, Your Lordship.
Assigned matter means for the purpose of fixing a date for hearing.
Your Lordship, two or 3 months it was adjourned, Your Lordship. 2 or 3 occasions it was adjourned, Your Lordship.
It cannot be assigned. First time it is appearing.
Yes. ডাকো 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 হ্যাঁ টপটা আগে ডাকো
Group 4 motion, item number 119.
মার্কটা স্টপ বলে দাও
Marked as stop.
Yes. Anyone appearing for the petitioner? Fileটা দেখি Today at the time of call, the parties are not represented. Full stop. In view thereof, let this matter stand. Yes.
We are appearing for Shamsel, Your Lordship.
Where were you, sir? At your instance, the matter was marked as stop. Interim order is there.
Yes, my lord. Yes, my lord. My lord, we have served a copy, my lord, on the last occasion, my lord. This is regarding that matter where the insolvency process had already taken place and there was a claim subsequently. This is for the period of 22-23. This is simply covered by the principle of the clean slate principle. After the insolvency process, we have already served on the respondents, my lord.
Who is appearing for the respondents?
My lord, we have served at one alternate address also. Income tax. My lord, we have served on an alternate address also, my lord, pursuant to the last order in Chorangi Square. My lord, the only...
Is your manager, where is Mr. Banerjee? Mr. Banerjee usually appears. Nobody is there. Yes, you are there.
No, I am not there.
Sir, he is saying that by reasons of a clean slate principle, everything goes. Everything he has given a go by to. You're right, everything. You're not entitled to maintain your claim any further. Do you have anything to say?
But I don't know that what is.
Take instruction in the matter.
Tomorrow.
My lord.
Same position. Take back your file.
Let a copy be given to him.
My lord, I'm
Yes,
sorry.
hand over everything to him.
আপনার নাম দিয়ে
See, there is an order passed by this court on the previous occasion. That is on 21st of May 2024.
we had served it also. আমরা নোটিশ দিয়েছি আপনাকে চিঠিটা দিয়ে।
By this, you have deemed to have been the liabilities of the corporate debtor are deemed to have been irrevocably waived and permanently extinguished and written off.
Lord, I will come back tomorrow, my lord.
See the order. Kindly go through the order once.
We are supplying copies, my lord.
শুধু not today রাখো, কালকে আসো। And don't come and say I asked for an affidavit.
No, my lord. It's a point of law, my lord.
Yes. Because I'm not going to stay these proceedings and retain them on the file. Get ready and come and argue the matter. I'll fix the matter on a particular date and hear it out.
Grateful.
Group 4 motion, item number 3.
Lordship, I'm praying for adjournment. I'm praying for adjournment. The client has said that he will be appointing a senior counsel.
Very well. Since an accommodation has been sought, first time. Since an accommodation has been sought for on behalf of the petitioner, no urgency. Let this matter stand adjourned and appear in the monthly list of August 2024.
Lordship, August is too
Yes,
far.
yes. We are in June, end of June, middle of June. So August is
Lordship, July.
next month, August 2024. Yes, call the list.
Item number 4.
Item number 4, I'm praying for not this week.
But I'm opposing it.
But I am
Lordship,
on behalf.
Lordship, for item number 4, I am praying for not this week as the learned advocate, Mr. Sandeep Choraria, appearing for the petitioner could not come to the court due to his personal difficulties, my lord. That's why I'm praying.
This is a wise challenge, my lord. I don't know whether they have served the Advocate General, my lord.
No, this is his mother.
On the list, let him complete whatever he wants in the meantime.
Milord, next week he will complete all the, because some other items are also there. So kindly due to his mother illness, he's engaged.
Next monthly list, July. I'm placing in July. You come back, you complete whatever your formalities are. Thereafter, I'll take
Next
up
week.
matter.
Is it possible for next week, Milord?
Continue with the other
You
matter,
want
your formalities and come back. You serve everyone, whoever you want to, and come back. I'll consider it.
We have
Since
served, Milord.
has been sought for on the ground of the petitioner, on behalf of the petitioner, let this matter stand adjourned and appear in the monthly list of July.
Grateful, Milord.
Yes, call the next matter.
Item number 5.
Milord, 5 and 6 are same, Milord. 5 and 6.
Opposing, my lord.
Yes. July. Yes. Give your appearances. You are giving them.
Item number 7.
Yes, anyone is appearing? The government pleader is there. You are there?
Yes, my lord, I'm there.
File. None appears on behalf of the petition. You are there?
For appellant, ma'am. For the petitioner, ma'am.
Continue.
My lord, GST's interception and detention took place, and the penalty was imposed upon the detained goods and conveyance.
Where?
And the penalty, imposition of penalty and as well as the detention, all have been confirmed by the appellate authority, and I am against the appellate order.
Where is the appellate order?
My lord, appellate order is at page number 59.
Has he paid?
59.
While maintaining the appeal, first appeal, he has paid. This is before the tribunal. You secure this.
My lord, what happened, my lord?
He has obtained release of the he's obtained the release of the vehicle.
Release of the
Right.
goods
Issue is not that.
upon furnishing of the bond and the bank security on protest.
Yes.
We have taken the release of the goods, but we are now on the imposition of penalty, detention as well as imposition of penalty.
For that, I have to hear out this.
That has to be.
Where is the order impugned?
Order impugned is at page 59, my lord. My lord, what happened, my lord?
Appeal has to be heard. This is an appeal.
Yes, my lord.
This is in the nature of appeal under section 112 of the Act.
Yes.
So the moment the tribunal is constituted, I'll send lock, stock and barrel there. Everything will go there. But I have to entertain this. Otherwise, I have to hear out today itself. Both is possible. If you want to argue and complete your matter, I'll hear out today. But for that, the records, the entire records should be here. Have you annexed everything?
Yes, my lord. Everything has been annexed.
Mr. Siddiqui, everything is there. What is the challenge?
But all the mobs, my lord, this mob 1, mob 2, mob 4, those are not annexed here.
No, mob 1 has been not annexed. Mob 2 from mob 6.
Order of detention is there, adjudication order is there, show cause notice is there. Those are there. Appellate order is
See,
there.
these matters have to be heard.
My lord,
Mr. Rai.
what
Mr.
Mojumdar?
Mr. Mujumdar, these matters have to be heard.
Yes, my lord.
You have a statutory right to prefer an appeal under section 112 of the Act. Fair enough. There is no appellate tribunal.
Yes, ma'am.
So this court will entertain the writ application on that ground. Now you have got release of the entire vehicle about furnishing of security. So for you, there is no question of securing the balance now.
What I am praying, my lord, kindly hear me out. Then whatever your lordship will decide, I will.
No, either I dispose of your matter. If I hear you have to dispose of your matter. No question of granting any interim order.
No, there is no question on that.
Then
the dispose of
the matter has to be heard. Mr. Siddiqui says all the documents are not here.
The government pleader is leading.
Government pleader is there.
He's leading.
Yes. So the
certain documents are required.
But I have to entertain the writ application.
Mob 1 is the most important thing, my lord. Page 65, lordship sees, my lord. He was the driver moved without a valid e-way bill. And the driver's statement was recorded in Mob 1, where he said that I'm transporting the goods from Kuchbiar to Samuktola. That's it. So when he admits that he did not have a valid e-way bill.
So this is under
Mob 1 becomes very important. I don't think
129.
Under 129.
Right.
My lord.
Yes. So I have to hear out the matter, sir.
Well, it has to be, and Mob 1 has to be on record.
Tell me, what interim relief are you seeking? You tell me.
I am what my
You want
submission.
disposal of the matter, entire matter.
Yes, my lord.
So for that, the documents should have been here. You have
My
not
lord,
disclosed any documents.
only the MOB 1 is not there.
It is not there
That's
today.
the most important. That's the most important document.
I'll grant them opportunity to file affidavit in opposition. In the indirect name, if the tribunal is constituted, I'll send him back. It is easier for you. Otherwise, I'll decide it.
I am not in the MOV 1 is not in dispute. The statement of the driver is recorded in other documents.
MOB 1 may not be in dispute, but the MOB has to be considered by this court. I cannot decide this matter in a piecemeal manner, Mr. Mojumdar, can I? Challenging inter alia, the order detail. 11th March 2024.
Yes, my lord.
11th March 2024 passed under section 108 of the goods. This is 108.
107.
107
7 of the WPG.
West Bengal GST and Central GST Act 2017, hereinafter referred to as said Act. The present writ application has been filed. Full stop. It is the petitioner's case that the petitioner has a statutory right to challenge an order passed under section 107 of the said Act before the appellate tribunal. However, since the appellate tribunal under section 113 of the said 112 of the said Act is yet to be constituted, the present petition is being moved. Full stop. Having heard the learned advocates appearing for the respective parties and taking into consideration the fact that the tribunal that the tribunal that the appellate tribunal under section 112 of the said Act is yet to be constituted, I am of the view that the writ application should be heard. Full stop. Let affidavit in opposition. Full stop. The respondent shall be at liberty to file their affidavit in opposition to the present writ application, disclosing therein all documents they wish to rely on. Full stop. Full stop. Let such affidavit be filed within a period of. Yes, sir. Within a period of 3 weeks. Within a period of 4 weeks from date. Full stop. Reply, if any, they are to be filed within 3 weeks thereafter. Full stop. List this matter. Now, full stop. Liberty to mention upon expiry of the period for mention of liberty to mention upon expiry of the period.
আফটার অ্যাপিলেট অর্ডার কিছু টাকা জমা করেছে
দেখতে পাচ্ছেন
কোথায় রেখেছে কোনটা ডিসেম্বরটাতে
আসলে এগুলো আস্তে আস্তে ডাকুন 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 I have to hear out these matters.
This matter.
Item number 8, in the interregnum, tribunal is constituted.
You are hopeful, my lord, it will be constituted.
Milord. Transferred. Although the court can hear out the matter, but they can always transfer so that subsequently the matters can come back.
Milord, item number from 8 to 10, same as 4, 5, 6 July monthly list, Milord.
8 to
10, 8, 9, 10.
All these are different matters.
Oh, yeah.
Yes, different matters.
One more is there, that is 13, Milord. 13 is there also, only.
Yes. 11, 8 to 10, same order.
11 number.
These are not similar matters. Alada alada. সব আলাদা 9, 8, 9, 10.
Item number 11, please, your lordship, I am for the petitioner. Here also, lordship, I have exported an item, your lordship, goods for which I paid for refund. I paid application for refund. That was rejected on the ground that the suppliers of my goods, supplier is
non-existent.
That is the question. Now the first question, your lordship, the impugned order, your lordship, was passed 102. This is your lordship to turn to page 112, your lordship, the observation being given in the order in original.
9, 10, 112.
115,
111.
115, the inward.
No, thereafter you file an appeal.
I prefer an appeal. Here also, they are
they have relied upon a report which has been supplied to me, but the report, Your Lordship, is absurd. Because in a building, they went to one of the floors, and took two witnesses, Your Lordship. May I think, suppose, Your Lordship, this is sacrosanct. The report is sacrosanct. May I just submit in this way? The report is sacrosanct.
Sir, you have a coextensive liability. You have a coextensive
Lordship, I do have-
liability. But your primary liability is not on you. That you're trying to say.
Primary liability is not on me.
But you have a coextensive liability which is not available. You have to pay.
No. You have to. This person is there. I have extensively given the evidence, Your Lordship. They are not taking into consideration the evidence. What they are saying, I went to the.
Made that person a party here in the petition?
No, I haven't. I should have made. Lordship, may I make him this
Oh,
person a party?
Not necessary. I'll dispose of your matter.
Lordship.
Proceed. You have not made that person a party also. If you are so interested, you could have made him a party.
Party, Your Lordship, this. But this has not been the procedure being followed. Being a revenue lawyer, this should be basic things we are lacking. We should have made him. No, this is necessary.
You are saying that he is there, available.
He's very
You
much
should have made
available.
him a party.
Lordship, this.
Now I know no further chance. Conclude your submission. This is the only point. Show me the order.
Lordship, the order being.
Final order. Yes. US, look, there is no violation of principles of natural justice, sir.
There, I was not allowed to cross-examine. I was not allowed to cross-examine the person. The person, the report, Your Lordship, I beseech Your Lordship to turn to the report. Page 103 and 104, the report being there.
Yes.
In the report itself, Your Lordship, there is no question, Your Lordship. Two persons have been examined. As per the report, 2 persons have been examined on the second floor. And there is no other examination of any other person on the second floor. In a big building, if 2 persons are examined.
Who is Ashok Kumar Sahani? Sani. Who is Ashok Kumar Soni?
He's the proprietor of JS Enterprise.
JS Enterprise proprietor.
And you are?
Radhika International.
Now, that GSTN number is there.
Lordship, GSTN number is there.
GSTN number is there.
Very much so.
Mr. Government Pleader, the GSTN number is there.
HON'BLE.
You have not cancelled the number.
But Mr. Siddiqui is.
I will not cancel the number.
No, it was not cancelled at the point of time.
No, it was cancelled subsequently.
When did you cancel it?
No, it was cancelled.
When did you cancel it?
His registration was cancelled.
When? You can't have both. Either you say that the GSTN number, if it exists, if you have not taken any steps, then you have to proceed against him.
No, we have proceeded against him.
When have you proceeded?
My Lord, if your Lordship kindly sees the adjudication order.
Yes.
The original order.
Yes. Show me the original order.
Cancelled on 17/1/2021.
17/1?
Effect from.
21.
It was from effect from 17/1/2021.
When was it cancelled? Date of cancellation?
Date of cancellation has not been mentioned here also.
He has annexed that note.
No, is the date of cancellation after the visit?
After the date of cancellation after the visit. And the visit is on 18th January 2023, which is at page 103. Which is at page 103.
I've seen that. I'm on that.
My Lord.
And cancel. Where is the order of cancellation?
Order of cancellation, he has not annexed, but that is, my Lord,
not,
there. And that is
No,
there.
you should be having that. You show me that, Mr. Siddiqui, one thing. You show me that when have you cancelled, what steps have you taken for cancellation?
Lord,
And when was it cancelled?
If your Lordship kindly comes to the appellate order.
Yes.
Page number 124. Lord, if your Lordship kindly says the last.
Now cancel. I've seen. Thus it transpired. Now cancel. When is now?
After that inquiry report with that inquiry report which your Lordship was seeing the earlier paragraph.
No, when is the order? Appeal is 29th of April 2023.
My lord.
And original order?
Original order is
Order
not
on
Order in original is dated?
dated 17th February
February
2020
2022.
2023.
Wait, page.
Page number 111. Starts from 111. It goes up to page
And your
111.
cancellation is thereafter.
Thereafter, your lordship, with
Cancellation
retrospective
was
effect.
during the my lord,
You have passed the, please wait, sir. You have passed, I understand. You have passed the order in original in 2022.
2023.
At that stage, you did not cancel it.
was 17th of February 2023. Adjudication order is
No,
No.
order in original is
13,
refund rejection order. That is the one.
12th of December 2022.
2022.
No,
12th
that
of
is the
December.
period.
No.
ARN is number, then the period is August to August.
Your lordship kindly comes to page 115. It starts from page 111
Yes.
Clause 4.
and page 115. Your lordship kindly sees the digital signature. The date is mentioned there. 2023.02.17. That is 17th February 2023.
Very well.
My learned friend should have.
No,
Very
the
good.
order is dated here, Lord.
Kindly see clause 4, my lord. It also says
So it is
central authority is also cancelled.
very well. What is now the next point is, therefore, when did you cancel it? If your cancellation is post this, there is no difficulty.
Cancellation is earlier to the adjudication.
Means cancellation has to be prior to this order or the
Right,
original.
it
Where
is
is
prior.
this? Where is
My lord,
this?
that transpires from this order only.
4. Page 115, 4.
Yeah, I've seen that. It is says that it is cancelled with effect from 21. But when
Central authority has done it.
observation of the undersigned, page 115.
আমি adjudication order pass করছি, he was not cancelled.
If you have not, the only
have
issue
some-
is, only you can understand this. When you pass the adjudication order, it was not cancelled, then it was an entirely different issue. Now, it appears that from the adjudication order itself, that by the time adjudication order was cancelled. When the proceedings was initiated, when was it?
Against the supplier.
No, refund, sanction, rejection order. This is August 2022. Show me when the proceedings was initiated. If that person is there today, then you have to catch hold of that person.
Under the breath.
Acha, assuming for a moment. Today that person's registration has been cancelled. What happens? He cannot proceed against that person. So he has to proceed against you.
No, my lord,
He has
I
to
am
proceed
not on
against
that.
that person.
My lord, I am not saying
Subject to
that
your
he
lordship's
has been
correction.
pleased by his supplier. I say that entire transaction is fictitious.
I
This
see.
is paper transaction.
According to them, it is paper transaction. If it is paper transaction, lordship,
This is the way by which he is
if it is
wrongfully
paper transaction, your lordship, how can you get the
then he is hit by section 16.
no? Then the entire export is also fictitious.
Yes,
The export is also fictitious.
From the adjudication order.
No,
Show me that, show me that.
fictitious. What he is trying to say, your lordship, that
Start from page 114.
if the transaction is fictitious,
That's how
if the transaction is fictitious, your lordship, the export is also fictitious. Say that the export, your lordship, is fictitious.
Go and tell to the custom department your export was fictitious or not. Lordship kindly sees, my lord. From the page 114. On the top.
Huh. Yes, I've
Lordship,
read it.
Lordship, if the transaction, according to my learned friend, the transaction entire chain is fictitious. Now the export is also fictitious.
What are you asking for? You are asking for unutilized portion of the input tax credit.
Tax credit.
Correct?
Lordship, this.
Now to that, see the observations at page 115. Place it.
Lordship, this.
These are the 4 points. Place it.
Lordship, the applicant has filed an application for refund on export without payment of tax is covered under 54. Invoice and e-way bill as possessed by the applicant do not indicate inward movement, and delivery of goods as such instruments are generated by the applicant himself or any other representative. It is also to be noted that e-ways are not endorsed by the department. There is no scope of endorsement by the department. Now the check post is not there. In the Value Added Tax Act, Your Lordship, during that period, the check post was there. If you take the goods from one place to another, you have to get it endorsed. Now there are moving vehicles, Your Lordship, of the department. They catch hold of the person. There is no endorsement. According
Very
to
well. Next point, section 16
applicant
to
had received goods for entitled, but the spot inquiry on 19/120, it has come to the knowledge that the applicant does not conduct. It is not that the supplier. Applicant does not conduct any business from the declared place of business and only invoices and without supply of goods in violation of the provisions of the Act or rules thereunder. Here, it is the applicant does not. The applicant does not act. Your Lordship, it is not the supplier.
Next.
The central authority has also cancelled the GSTN of the supplier with effect from 17/1/2021. That is the moot question.
From that day, he's not there.
there.
Lordship,
You say that you don't have a liability.
Lordship,
You make out a case that you don't have a liability, then I will hear out.
Lordship, under the judgments, Your Lordship, there is a line of cases that have been developed, Your Lordship. The Bethel Enterprise, the judgment of Bethel Enterprise,
Show me.
they should take into consideration. Lordship,
Consideration what?
tomorrow. They should at
I am
least
hearing you. I know adjournment now.
No, initiate proceedings, Your Lordship, against
Show me.
the Bethel judgment.
আমি কেন রাখবো? তুমি দেখাবি, আমি
You should have got ready with the matter before starting your matter.
Lordship, this Bethel, Your Lordship, the Bethel judgment also.
Where is that judgment?
It has not been with me, Your Lordship.
Then you are starting arguing the matter without having a judgment in your hand. And you want to rely on that judgment.
Bethlehem hai jo.
Sir, there are so many
Lordship,
matters
there
waiting.
are so many matters, Your Lordship. Sorry, just
Next month the list.
Lordship, this.
Wait for that.
After arguing the matter for some time, since the learned advocate representing the petitioner placed for an accommodation, let this matter stand adjourned and appear.
Sorry, Lordship, this is deeply. Lordship, I
The
did not envisage you can take this point, Your Lordship. This is extremely.
Yes.
Lordship, this. কেন আমাকে দিয়ে তো করবে বাবু, আমার কাছ থেকে নেবে
ওকে পাঠিয়ে দাও।
Item number 12.
My lord, I am appearing for the petitioner, my lord. My lord, the issue is the disallowance of ITC against the taken against the ab initio cancel dealer.
I couldn't follow.
Disallowance of ITC
Disallowance of ITC
by the authority against that adjudication order, we preferred an appeal, and the appellate authority also confirmed the appellate order. So
Then this matter has to be heard again.
has to be heard. Like the earlier one, this has to be heard.
Where is the order?
My lord, order impugned is at page 54, my lord.
54 is the appellate order under
Yes.
section 107.
Yes, my lord.
Appellate order dated 13th March 2024.
Mr. Mojumdar, where is the original first order under, where is the first order?
Original order is page 33.
This is under 74.
74.
74. 74 subsection 9.
Suppression.
No, suppression is not there.
74.
74.
Fraudulent availment of ITC. That is the
Yeah.
case made out by the department. So it has to be heard.
Very well. Challenging an order dated 13th of
March 2020.
March 2024. Passed under section 107 of the CWBGST CGST herein after referred to 2017 year. The present date application has been filed. Taking into consideration the fact that the order impugned in the present application is appealable under section 112 of the said act, and that the appellate tribunal under section 112 of the said act is yet to be constituted, comma, let the writ application be heard. No, the writ application shall be heard, full stop. Let affidavit in opposition to the present application be filed by the respondents within a period of 6 weeks from date. Reply, if any, there to be filed within a period of 3 weeks thereafter. Liberty to mention upon expiry of the period for exchange of affidavits.
My lord, your lordship has given direction for affidavit exchange, but it's a covered issue. Man. It's a covered issue.
But matter has to be heard still then. Covered by which judgment?
Covered by Sanchita Kundu, the judgment delivered by the predecessor Justice Nizamuddin Malik.
Where is that judgment? देखिए एक बार करो.
This is not applicable. Lordship will hear this.
Yeah, so you want to argue this. You will argue this. So next it.
Sanchita.
कर दियो.
23.
Item number 13.
Milord, for item number 13, it's a case of bank attachment, Milord. Kindly keep it in the next week, Milord, because the matter is very urgent, and the learned advocate whose mother is ill, they are in Delhi. He has gone to kindly keep it because urgent matter, Milord. To can't hear you, Milord. I can't hear you.
What is the urgency?
Urgency bank attachment, Milord, because the petitioner cannot operate his business activities. It's very urgent, Milord. That's why
order.
Kindly keep it in the next week, Milord. Any day, Milord. Any day, Milord.
So this is an appealable order.
Let it appear next month later.
Milord, try to try to kindly consider the gravity of the situation, Milord. That's why
Yes,
I'm
tell
saying
me,
that
what is the urgency? Urgency is a bank attachment is there, but the order
bank
is
attachment there because of that the petitioner cannot operate his business, and the business is totally stalled because of that. Kindly any day, Milord, any day.
filed the
It's
order.
my request. It's my prayer, Milord.
No, you move the matter today. The matter is there in the list.
There is some
He has gone to take back his mother because he fell ill there in Delhi, Milord. That's why he will be back within.
So you ought to have, if there was so much of urgency, you ought to have made an. You see, at the end of the day, if there is urgency in the matter, you say on one hand, you could asking for an adjournment not for 1 day, for another week you are asking for.
Because it will take time to come back. That's why, Lord, I'm praying.
difficulty
That's
today.
why any Monday or Tuesday.
Next month list. Next month
No,
list.
no, it will, your petitioner will suffer a lot, my lord. So kindly consider my prayer. At least I'm the junior of learned advocate, so I will lose my credibility also. So kindly.
Yeah, make alternative arrangements. Please, I'll place it tomorrow.
That's why kindly only because of 8 matters I did not insist, but only for this matter, my lord. Kindly, any day, my lord. Monday to Friday, any day.
He's challenging page 96.
Yes.
No, that's the show cause come demand notice.
No, that is the adjudication order is at the end 110. 22nd March 2024.
Yes.
Fifth April টা কোথায়? 5th April টা কোথায়? 5th April, এটা 108.
What is the ground of challenge?
Because I have no knowledge about this, because I have no brief with me at present with me, my lord.
No, then I'll next month list.
At least next week or
No, next month.
Convenient.
Wait, tomorrow
Next.
I'll tomorrow. If you have an
Milo-
urgent, is it tomorrow? Otherwise, next month list.
Tomorrow won't be possible. He won't be able to return back. That
Therefore,
because of that.
next month list.
Any day after next week, third week,
This is
second
an
week or
appealable
third
order. Why should this court take up this matter at the first instance?
urgency, my lord, because of that.
Sorry, what urgency? Why will this court take up this matter? This is an appealable order. What is the ground of challenge? Find out, Mr. Banerjee, find out kindly.
Page 12, paragraph 24.
You have not enforced this order as of today?
But they are saying that they have enforced the order. I mean, we have no instructions because the executing authority is another. Since they did not submit the appeal or whatever appeal papers, so natural consequences of might have been continued. Instruction, whether any attachment has been, which shall take instruction.
Audit proceedings were initiated
Yes.
under section 65.
Now that audit proceedings culminated into the show cause notice.
So what is the difficulty then?
Now the adjudication was done with regard to the concretization. Audit is just a preliminary objection, preliminary observation.
No, after the audit also, under section 65 also, you can proceed, and after
That
the audit,
culminates into the show cause notice, because since the audit could not, they could not.
and ASMD 10 was also served on
Yes.
them.
Yes, that is recorded.
Nothing is there in the matter.
As lordship thinks proper, I repeat. As lordship thinks proper.
এই সপ্তাহ পরের সপ্তাহে দিয়ে দাও, এক সপ্তাহ ছেড়ে
Grateful, my lord. Grateful.
2 সপ্তাহ বাদে দিয়ে দাও, মান দিন, ডেট দিয়ে দাও 24 তারিখ। ডিফিকাল্টি আছে থাক না, কোনো অর্ডার হবে না। If I pass the order, then I'll place it next month the list. That's the difficulty. Date দিয়ে দাও 24 তারিখ, 24th.
Grateful, my lord. Grateful.
Come ready on that date. I'll dispose it.
Item number 14.
My lord, I am praying for the time on behalf of the
Why?
petitioner
Why?
because senior is engaging another person.
Next monthly list. What is the challenge?
Challenge, they have come with a audit objection. Thereafter, my lord.
Next
nothing
monthly
has
list. Since an accommodation has been sought for on behalf of the petitioner, let this matter stand adjourned and appear in the monthly list of July 2024.
Grateful lordship.
कागज नहीं है। और respondent करो।
Item number 15.
এই এসি গুলো চলছে না? এসি গুলো চলছে না সবকটা এখন?
এই যে এটা নিয়ে নিন 14টা নিয়ে নিন। না না লিখে দাও নেক্সট মান্থ।
এইটা তো চলছে না, চলছে। কি জানে বই যাচ্ছে না বেশ। ঠিক আছে দেখো চলছে না, খবর না।
এটা 14.
Yes.
Your Lordship, in this writ petition, we have impugned the order of the West Bengal Divisional Board. Right. In this order, Your Lordship, in this order, we have impugned the order of the West Bengal Divisional Board, which is pertaining to our central sales tax assessment for the year 13-14. Your Lordship, this is the second round of litigation before this honorable court. Your Lordship, kindly come.
Lordship, in this matter, I will seek time before my learned friend starts. I will seek time in this matter, Your
These
Lordship,
matters are all
because
these
there's
are all in the list, sir.
no.
This was there in the list. Somehow, my lord, we missed this matter only. We were supposed to take instructions from the department. Lordship, can you take it after 3 days, my lord? We'll come back. After 3 days.
Not this week. Not this week. Usually all these matters were printed. Previously also it was printed.
Just today in the morning when I
And
went to
this set is being taken up. This part 1 is actually those matters which had not been called on.
somehow, my lord, only this matter, my lord, we missed.
Very well.
Item number 16.
My lord, my writ petition, my lord, I am challenging an income tax assessment order post revision on the ground that it's a nullity without jurisdiction, being in contravention of an approved resolution plan under the Insolvency and Bankruptcy Code. Despite noticing the fact that the resolution plan has been approved, despite it being brought to the attention of the authorities.
When was the proceedings initiated and when was it approved?
I'll tell you, Lordship. Lord, the proceedings were initiated.
Prepare a list of dates. It will be easier. It's
Lord,
there.
there is a list of dates, but my lord, kindly see page capital A, which is effectively the 3rd page of your Lordship's paper book. My lord, this list of dates may not really assist your Lordships because
could have properly prepared the list of dates. This
my lord,
is a provision
the dates are there.
Yes.
My lord, may I give your Lordships the 4 relevant dates, really speaking? My lord, the CIRP, in respect of the company concerned, was on 10th of November 2021.
Where is that date?
My lord, that your Lordship will find.
Yes,
my lord, serial number 3. Kindly permit me to deviate from the list of dates because I have a handwritten noting. I'll connect it with the list of dates. My lord, in 2019, there was a round of assessment.
Sir, you are ready on the matter because nothing spoiling.
It's a question of law.
Yes, point of law, my lord. My lord, we are relying on a judgment of Supreme Court, my lord, where it is said, my lord, the recovery proceeding can be initiated, my lord. No final order can be passed. But they are saying no, nothing can be because the matter is pending before the.
I'll deal with that.
That is trying to make out a because there was a matter in the morning.
I'm also appearing in this matter, but somehow I was engaged in other.
I've recorded that in that particular matter. I've recorded in the order that everything is deemed to have been waived.
Yes.
And everything is extinguished.
Yes.
So if you're ready with the point, then you argue the matter. Otherwise, I'll place it on another day.
It's not because my
Same
learned
point.
friend,
Our point is the same.
I'm not there in that
was
matter.
there in that matter.
Yes, yes.
Not
Sub-
because
Sabha
the
English
judgment
another
my learned friend relies on is on the impact of the moratorium during. I am on a post situation.
Yes.
So totally different. But my lord, I don't mind it being kept on another day.
No, no,
but
the finally
any day
heard and
convenient to
disposed of.
it's a question of law. There's no
Pure
dispute, question of
law,
fact.
yes.
But any day that is convenient to you,
Both the matters I'll take up together. When is that fixed? When is the other matter
that's
fixed?
fixed.
Yes.
Tomorrow I'm told.
Tomorrow,
My lord, tomorrow we'll come back. My lord. No difficulty. I have no difficulty on any day that is convenient.
Next Monday? Next Monday?
Why next one?
Very well. Let this matter be taken up for consideration along with along with WP.
119 serial.
Serial 119 বলছে।
Serial 119 11796
11796
Huh? হ্যাঁ ওটা not to along with the ওই ডেট দিয়ে দাও next Monday. Next Monday.
But I'm appearing in that matter also.
You are also there.
Yes, yes.
So ওইটা না ওখানে কোনো অর্ডার দিইনি তো শুধু ওটা ডেট দিয়ে দেবে ওখানে।
Next Monday ছুটি বলছে।
Next Monday is a holiday, I believe.
Tuesday, Lordship.
Because, my lord, could it be this week, subject to your lordship's
Tuesday, Lordship. Lordship, Tuesday, my lord. I'll take full.
You have a difficulty?
Tuesday.
No,
No, my lord,
I have difficulty. Yes, tell me.
I'm checking my phone calendar. That's why.
There no difficulty.
My lord, instead of Tuesday, may I pray for then Thursday? ঠিক আছে, 20th.
Excepting Friday.
Very well. Kindly keep it on Tuesday. I'll come.
Excepting Friday. Friday I do not take up these matters.
This week could it be Thursday? No, হবে না। ঠিক আছে। And my lord, any day, my lord. I'll come back on Tuesday. In the meantime, no order is required.
We'll not take it.
Dudoria, I've recorded that in the other matter.
Yes.
Yes.
That what will be the impact of the order.
Yes.
Go through that order.
Yes.
Because
Lordship, kindly.
here, my lord, I'll show that they are not only cognizant, their reason to disregard that is my notice was before. So I don't care if your plan was approved. My notice was before, therefore I can disregard it. That is their written stand.
Where is that? Show me. Just once.
Yes, that is in the impugned order.
In this matter.
In this matter. Kindly take page 47. That's the impugned order. That's the effect to order under 263. Now, my lord, kindly see para 8.8 at page 53. Para 8.8 at page 53. May I just place it for your lordship's kind consideration? Page 53. Lordship has 53. Para 8.8. In the instant case, the Honorable NCLT Mumbai bench passed its final order on 18/10/2023. Well, that's the order approving the plan. And the proceeding under 263 was initiated vide show cause notice dated 14th March 23, which is much before the date of the said order. In view of the same order under 263, dated so and so is valid, and therefore to give effect to the order under 263 by issuing notice is also valid.
No, where is the order passed by the NCLT Mumbai?
That is, my lord, 18th October 23. Your lordship will find that at page 152. And interestingly, in that order, which is not challenged, kindly come straight to page 174. This is the judgment that your lordship was referring to today. Kindly come to
150.
152 is where it starts. Kindly straight up.
Second volume.
It's in the second. I'm
Second
so sorry.
volume,
Yes, it's in the second volume. 152 is the order approving. My lord, kindly.
An effective date?
Effective date is, my lord, the date of the order. That's defined in the plan itself.
Where?
My lord,
where is it? Where is it?
my lord, 152 is the order.
Yes, defined.
Oh, your lordship is asking for the date of the order. At the first page.
No, effective date.
Effective date, I'll show your lordship. My lord, kindly straight away come to 246, same volume. That's in the plan, the definition of effective date.
Yes.
Kindly come to page 246, right at the top. Effective date means, this is part of the plan which is approved, means, means one, when the order of the adjudicating authority approving the resolution plan is not judicially challenged, in our case it was not judicially challenged, the date of approval of the plan by adjudicating authority. So, my lord, in other words, 18/10/2023.
So, it is the date of the order.
That's right.
Effective date is the date of the order.
That's right. My lord, as on that
But
day,
by that time, the proceedings had already been initiated.
started. This impugned order comes in the year 2024. It's in March 2024.
Maybe,
5
but
months
by
after.
that time the proceedings had already
Yes,
been initiated.
but my lord, by approval of the plan,
Does the plan, what does the plan provide for?
it's extinguishment of proceedings.
Show me.
Kindly come, my lord, I'll show your lordship only 5 pages from the plan. Kindly bear with me.
Yes.
Kindly come to, my lord, page number 196 straight away.
196.
And my lord, now I'll show
Just a
the
minute.
order also. Kindly come to page 196. My lord, the heading 3.5. Lordship sees. This is proposal for operational creditors, statutory liabilities, including outstanding dues of government dues, taxes, etc.
So you had notice of these proceedings, Mr. Dudu?
They've lodged their claim. And they've got a very, well, I don't even want to say the amount, but under the plan, they've got
XYZ amount.
XYZ, or rather in this case, nil.
Nil.
Nil. That's the plan. Nobody has challenged the plan. They have got nil. And my lord, your lordship was asking me, kindly have a look at 3.5.5a. Extinguishment of all proceedings.
3.5.5a.
At page 198. Right? There are several clauses. I'm just pointing, because now it's such a verbose, my lord, drafting of these plans to ensure that nothing slips through the net. This is just one of the places. Kindly see the last 5 lines on that page.
No, as set out in Annexure 8.
And any consequential taxes should be considered as non-est in law. Last
No,
line.
Mr. Mitra. All tax, including
Including. My lord, this covers everything, my lord, and I'm showing your lordship only by way of example.
No,
Kindly
that
have
is
a
not
look.
paid.
All
Including is
taxes.
bracketed. You see, all taxes
Results.
under the applicable provisions of applicable law.
That's right. That's right.
And then it says, as
That's right.
set out in Annexure 8.
That's right.
So where is Annexure 8?
No, before that, my lord, kindly allow me to place it 200 also, see. Kindly also see 200. Clause E. Clause E, this is, my lord, absolutely clear now. With reference to direct taxes, indirect taxes, including but not limited to GST, so and so, so and so, so and so, municipal taxes, etc. 1. All assessment, reassessment, revision, penalty, appellate, or other proceedings pending in the case of the CD as on the effective date relating to the period prior to that date shall stand terminated. 2. All notices issued
Wait. All assessment, reassessment, revision, penalty or appellate or other proceedings pending in case of corporate debtor as on the effective date.
Everything goes.
Relating to the period prior to that.
And my lord, just for your lordship's information, this is relating to AY 2018-19. This is 18-19.
Actually, this has to be prior to this effective period.
That's right. And my lord, may I show?
No, this is only with regard to not be payable by the corporate debtor.
No, RA also.
Where is that?
Everywhere, my lord.
Show me, sir. You have to show
I'll
me.
show, my lord. Whenever your lordship keeps
You have to show me. You can't just say that since this does not
suffice it to state that I have marked
the state
every
will be losing a huge chunk of money.
State.
So I have to be doubly sure for that.
Triply sure.
Yes.
And I marked every clause. Whenever your lordship keeps it, even today I'm ready. But since, my lord, your lordship is minded not to take it up today, I'm prepared, my lord. And I'll, for your lordship's benefit, what I'll do is I'll cull out the clauses on a separate sheet of paper. That'll be easier instead of your lordships having to mark it, and maybe a list of relevant dates. Only 7-8 dates are relevant. I'll restrict it to that. And my lord, will kindly have a look once at the order also of the adjudicating authority. That is also important. Kindly have a look at 9, Roman 9, page 174. That's the order of the NCLT which has not been challenged, which is binding now under 31. Supreme Court has said it is binding. It says The order says that all the claims which are not part of the plan shall stand extinguished and no person will be entitled to initiate or continue any proceedings in respect to a claim which is not part of the plan. That's in the order which has attained finality. Kindly have a look at page 174, Roman 9. That's the operative direction. Further, in terms of the judgment of the Honorable Supreme Court in the matter of so-and-so, Ghanshyam Mishra, the Honorable Apex Court on the date of approval of the plan by the adjudicating authority, all claims which are not part of the plan shall stand
This act has
extinguished.
an overriding effect. Show me that provision also.
Overriding effect is not in the code. Overriding effect is Supreme Court.
Show me that.
Can you see section 31?
Yes.
It will be binding and, my lord.
No. Binding is one thing, sir.
My lord, I'll show your lordship, my lord.
It has to be a special statute, eh?
I'll show your lordship, my lord, a Supreme Court judgment which says IBC overrides Income Tax Act. I will show your lordship 3 judgments of Supreme Court on income tax dues extinguished post-plan.
But it is not provided in the statute.
No, it is, my lord, IBC by virtue of section 31.
Is there a non-obstant clause in the statute?
Yes, 238. 238
of the
IBC.
Yes.
My lord, have this, my lord. Your lordship may not have the latest copy.
Achha,
My lord, this is subjected to amendments every month.
Yes.
Kindly have 238. And my lord, this has received, my lord, judicial interpretation by the Supreme Court on
238.
Yes. And interestingly, my lord, this your lordships may have had.
This was wait, sir. Let us understand.
Yes.
So this was 238 introduced when?
This was in 2016.
2016.
That's right.
GST law.
Now,
when is that come in force?
Income Tax Act. This is income tax. 61.
This is income tax.
And
so GST. So it has no overriding effect so far as GST is concerned.
It will still have overriding effect.
Certainly not, sir.
Not because it's a later statute. Because it's a special.
Sir, the provision, not this clause, overriding effect is provided for in 238.
No, because
understand this.
Yes.
We clarify this.
Your lordship is maybe right on GST, but my lord, GST may not have a non-obstante. I'm not sure. But my lord, insofar as the Income Tax Act is concerned, I'm on a better footing.
What you write in your document
is
that all and sundry everything goes.
That's right.
Now, if that is contrary to the statute,
it's not. Section 31, kindly see, it is binding on the government also.
No, it may be binding, sir. It may be binding. But if something is contrary to the statute, then can it be enforced?
Yes. My lord, may I simply answer this?
GST 2017 Act.
Yes.
Is the latest statute.
That's right.
So when this section 238 was incorporated, it's in 30th of November 2016.
That's right.
So as on that day, GST was not there. So the legislature could not have contemplated that
your lordship
act shall have
right to that extent.
Overriding effect in respect of other acts in future.
Of course. My lord, a new tax law may come in tomorrow.
Correct.
But my lord, the intention is, my lord, may I answer it in 3 steps? Firstly, insofar as I am concerned, for income tax, I'm on a better footing because after the IBC, the Income Tax Act has been amended to say that the income tax authorities are bound by a resolution plan. My lord, I'm on.
Income tax is different, but I have read this.
Kindly.
So, apart from the income tax, there may be other matters also. So that is the reason why
GST is concerned,
I want to get a view from you also on this regard. Because I was going through this particular provision which you had shown me.
Yes.
Which page? Which page?
I showed your lordship, my lord.
And that particular clause.
That I'll show your lordship.
I've got it.
200.
Effective period is there. 200. Yes. Now 200 it says all assessment, everything under the sun.
That's right.
Including GST.
Everything goes.
Everything which was there.
Yes. Now
everything which was there.
Now, my lord,
in the year 2016.
Now, my lord, may I answer it in a 3-step process? By first admitting ignorance, tax law is not my forte. But since your lordship has raised
I want to know
GST,
from you.
Of course, my lord, I will check on the GST aspect, and I'm sure there are judgments covering GST aspect also. 2, Section 31 of the code said it is binding on government authorities also. 3, the Supreme Court has, my lord, in a number of decisions now, not 1, not 2, your lordship, and I have had the occasion to place them before your lordship in the context of a provident fund matter.
I have accepted your contention.
That's right. So, my lord,
But
the
that was
Supreme
in
Court
the context of a
provident
different
fire.
matter,
That was
provident
provident fire. But, my lord, here, my lord, the Supreme Court has said that the intention of the IBC is that every claim, regardless of its nature, will go. And
but still
there is no
but still then
inconsistency.
the overriding effect has to be there of the statute.
I understand what your lordship is saying. So, my lord, insofar as
The judgment also on this, which with regard to the later acts prevailing,
that's right.
Where you see there are two special acts.
That's right.
Which one will prevail?
Perhaps the later. Your lordship is right.
Yes. So
Special general, later, before. But, my lord, on the GS,
when it is a question of taxation, taxation, which will prevail?
That's true. So, my lord,
these are the questions you need to
so, my
answer.
lord, what I'll do is, my lord, in my case, I'm fortified by the Income Tax Act itself. But, my lord, since your lordship has raised the issue of GS,
Your scheme is not limited to income tax.
it is related. I understand.
Everything. It says including but not limited to GST.
Everything.
So therefore, this brings within
Everything.
its sweep everything under the sun.
Everything. Everything.
So that is what I recorded in the order in the other matter.
Everything. My lord, I'll satisfy your lordship on the GST aspect,
I'll
though it
wait.
does not come up in my writ petition. Since your lordship has asked me, my lord, I'll definitely, my lord, come back on the GST aspect also. But, my lord, it's now, I'm confident I'll be able to persuade your lordship on this.
I'll hear you Monday.
Very good. Monday is a
Tuesday.
holiday.
Tuesday.
Very.
Your lordship has passed order on 109.
You've already passed it. Just
Lord,
hearing
I was
after
there,
that.
sir.
19th বলা আছে তো
No, I was there in the matter, my lord.
এটাকে এই বইটাকে না
Oh,
আনিয়ে নাও
Very.
ফেরত দিয়ে দাও ওটা আর লিখে আনিয়ে নাও এটা 2000 latest amendment
My lord,
আজকে তো একটা
may it retain its position, my lord.
yes it will be in the monthly list only.
Oh, monthly list. Oh, monthly.
Huh? It will be effectively item number 1 on that.
I'm so obliged. Great.
তো বইটা ফেরত দিয়ে দাও
এক সপ্তাহে কি করেছিস?
হ্যাঁ হ্যাঁ কিছু করতে হবে না তো ওটা থাক টপ যেরকম লেখা আছে থাক মান্থলি লিস্ট তো চেঞ্জ হবে না তো কিছু মান্থলি লিস্টেই থাক লিস্ট করতে বলিনি তো আমি টেকেন আপ বলেছি তাই তো
And I'll come back with a short list of dates. It will be easier. My lord, may I place the affidavit and service? Sir?
on
But
the next
119, Lord, you said none appears, but I was there. Lordship, that order was.
then I already passed the order. Come back.
Great.
না ডাকো না স্যার বসে আছে
Item number 17.
But I'm for the respondent.
Order right.
My lord, petitioner herein is a limited company registered at ROC and filing its return before the ROC and income tax well within time for last 25 years. This year, my lord, what has happened, the chief accountant of the company had a heart attack, severe heart attack in May. From June, July, August, he was in the hospital itself, and in August, he resigned. Therefore, my lord, for ROC, I had to file the return by 30th September. Audit was to be completed, annual was to be filed, and then I am allowed 3 months more time by the income tax. Under section 1394, I can file by 31st December. Since the delay was there because of the illness, I filed a petition before the ROC that my delay should be condoned because of this reason. ROC was pleased to condone the delay, and they gave me 3 months more to file the return by 31st December. And I filed that return. I completed my audit in December itself, December 2022, and filed my everything before the ROC. Now, before income tax, since 3 months more time was allowed for completion of the tax audit report and others, I completed my tax audit report by March.
What are you asking for? Is a prayer?
Sir, I applied for extension of time to the CBDT since my time expired on 31st December. So under section 192B, there is a instruction of the government of India CBDT that if there is a genuine hardship, extension can be granted. So I made the application to the CBDT. The application was CBDT called for a report from the principal commissioner here in Calcutta, and principal commissioner also recommended that delay can be condoned. But the honorable CBDT did not condone my delay. Their order is, my lord, is at page 29 to 31. Now, what they say is that you could have taken a reply. Kindly come to page 30, para 5.3. Reliance is placed on the above judicial pronouncements. It is observed that management of the petitioner company adopted a casual approach and took more than 3 months to find a suitable replacement for its accountant. Willful negligence on the part of the management does not constitute genuine hardship, and delay in filing ROI is pointed to the lack of due diligence by the management of the petitioner company. No reasonable cause or genuine hardship has been made out by the petitioner that merits invocation the condonation provisions. Now, before that, my lord, on 30th top, the West Bengal PCCIT West Bengal has recommended already that delay can be condoned. Kindly come to page 30, para 3. By letter dated so and so, the report was called from the Principal Chief Commissioner of Income Tax West Bengal and Sikkim on merits of the petitioner's application. The learned PCCIT West Bengal and Sikkim by letter dated so and so has endorsed and forwarded the receipt of filed authorities to PCCIT West Bengal and Sikkim, has recommended condoning the delay in non-filing of RI for 2023. The field authorities have recommended condoning the delay.
ROI?
Yes, my lord.
What is ROI?
ROI.
ROI, return of income, my lord. Return of income. Return of income.
Yes.
Now, my lord, they say that this is not a genuine hardship. My lord, I have given all the details and documents. What they have done is they have relied on P.O. Bhandari's case. P.O. Bhandari's case, my lord, has been considered by the Honorable Bombay High Court. My lord will kindly come to para 18 first of the learned Bombay High Court judgment. My lord, 3 months' time have been allowed by Registrar of Companies for the same reason. Calcutta authorities, all field authorities up to PCCIT said it is a good cause for condonation of delay. My lord, to get a replacement of the chief accountant is very difficult. Within 3 months, how can it be done? And when ROC has given me up to 31st December, Income Tax Act otherwise gives me 3 months more.
Return is ready.
Yes, my lord.
Your return is ready.
Yes.
Is your return ready?
My already ready. I have filed the return along with the application itself.
You filed it.
I have filed it. I said that let it be done.
My lord, my instruction is, my lord, it was done by a chartered accountant firm, my lord.
You can't go beyond the order.
Yes, that is there. But
whatever is there in the order, you argue on that.
Yes, but one thing, my lord, what I'm humbly submitting, my lord, that person fell ill in the month of June, but not the books of accounts have been closed in the month of March. Everything was audited within March, my lord. He fell in thereafter ill in June. But what my learned friend said, he fell ill thereafter.
No, return of income is assessment year 22-23. So financial year is 23-24. No,
22-23, my lord.
Yes.
Assessment year is 22-23. So financial year is 21-22.
Yes.
He fell ill when?
In June.
My lord, I filed on 30.
2022. So 21-22. Chest pain in May 2022.
May 22, yes.
Financial year.
Yes.
End comes to an end in 2022.
Yes.
March 2022. Accounts are prepared only thereafter.
Yes.
During the financial year, accounts cannot be prepared. Can it be prepared, Mr. Dodoria?
No. March 22 and he fell in May. Ill.
And where is the letter of the West Bengal, the Chief Commissioner of Income Tax?
Letter is not given to me, my lord, but they have referred it to in para 3.
Where is the letter?
Letter, my lord, I don't have the copy of the letter, my lord. My lord, section 119 2C says.
To me, yes.
Section 119.
The income tax boy the
2B.
The board's instructions are there, my lord, at page 36 of my petition.
Yes. 2B.
Yes, my lord.
119 2B. Instruction to submit. B. The board may, if considered is desirable or expedient, so to do for avoiding genuine hardship in the case or or class of cases by general or special order authorized any income tax authority not being a joint commissioner of appeals or a joint commissioner of appeals to admit an application or claim for any exemption, reductions, refund, or any other relief under the Act after the expiry of the period specified by under this Act for making such application or claims and deal with the same on the merit in accordance with law.
Yes.
For avoiding genuine hardship, my lord, that is the
provision.
There is a provision.
Then
Board can.
Such instructions are there, my lord, at page 36.
In hardship and it has not
But
been
that-
done. My lord, according to him, that the auditor fell ill, therefore he could not prepare the thing. But my lord, it's a company. My lord, my instruction is, my lord,
you have
my
to
lord,
understand one particular
It's a
auditor
better
is there. Now you can't change an auditor overnight. Or a senior accounts officer cannot be changed overnight.
it has been done by a chartered accountant firm. My lord,
And your own authorities have, what do you say to this?
yes, my lord, by the letter of the principal chief commissioner, he said it may
Yes.
be condoned, but that is there.
He recommended.
He recommended for condemnation. That is there.
Once this recommendation was there,
Yes, yes. That is there in the order itself.
how could he ignore this recommendation without giving reasons for the same? What reasons have he given?
Lord, he has shown a judgment of a my lord Bhandari. That judgment was shown, my lord.
Bhandari is, my lord, considered in this Bombay High Court judgment. And they
Where
say,
is the Bhandari's judgment?
my lord, Bhandari's judgment is fully quoted in Bombay High Court.
You have the judgment.
Sir, my lord, I will give it tomorrow. Bhandari
Any
judgment, my
matters,
lord, has been-
send it to the monthly list of
my lord, I'm
April
sorry.
2025.
My lord, my
What is this?
my copies were ready, my lord. My
judgments to court.
My copies were ready, my lord. My junior has not brought. I am very
Not,
sure.
do not blame the
I am very
junior,
sure.
sir.
But
Take
my lord, this,
responsibility on yourself.
my lord will kindly come to page 13 of this Bombay High Court judgment, where this Bhandari has been considered, because CBDT also rejected in that case because the chartered accountant son was ill. And then the Bombay High Court considered the issue and then allowed the petition. Kindly come to page 13, para 9, the Honorable High Court in Delhi in the case of Bhandari. And they have quoted the relevant paragraphs, my lord. In this case,
paragraph,
kindly come, my lord will kindly come to page 13, para 9, Roman 9. The Honorable High Court of Delhi, by decision dated so and so in the case of BU Bhandari Patil Associates. Reasonable cause. Honorable Court has regarded the finding of the severity with respect, reasonable cause, genuine hardship, and diligence of lucid and cogent, and affirmed the following reasonable cause. In determining whether the genuine hardship is caused to the assessee, one has to see whether the delay in filing the return was due to reasonable cause or not. In this case, delay is attributable to auditor. However, in such a case, one has to see whether the auditor has a reasonable cause for delay or whether the assessee pursued the matter with due diligence. On the question whether the auditor has a reasonable cause or not, the fact do not show any medical exigency of the kind which would cause so much delay when a statutory deduction of the large amount was taken. The auditor has not even been able to mention the nature of illness. In my case, my lord, I have given all the details and evidences. In fact, considering the hardship caused to the assessee, it will be expected that the assessee will himself have information of the illness, having obtained it from the auditor at the relevant time. In this connection, it is noted that the auditor has mentioned that it was a big audit assignment and needed to his personal attention. Yet, its assignment is only delayed without any memory of extraordinary medical exigency, which has caused it. It is also noted that the delay in audit is 5 months and not a few days. Therefore, the general explanation of medical exigency without any detail does not explain. There was no detail of medical exigency. There was no evidence of medical exigency.
He did not apply the judgment at all in its proper perspective. Did not consider the judgment in its proper perspective. Ranka and others, where is that Ranka? Every day's delay need to be explained.
There was 1 day's delay, my lord, only. I am sorry, I gave.
How many days delay?
In that case, only once. In my case, my lord, 3 months delay.
3 months delay.
3 months delay, because 3 months are allowed even by the department, my lord, after the company's audit. Company audit was completed in December. Earlier it was September and December. Now since December it was completed, then up to March I am allowed the time.
Yes, sir. Where have you said that you have filed it?
Kindly see, my lord, page 23 of my petition. Which is the petition? Page 24, my lord, I am sorry. Kindly see, it is submitted. Kindly see para 3. It is submitted. The petitioner is accounted audited under Companies Act, my lord, got it on so and so date by the statutory audit measure so and so, and the TAR was also prepared on so and so date. The copy of the audited balance sheet and TAR is enclosed herewith. So I have sent the copy of the audited balance sheet and TAR. Return I can file only
When have you filed it?
I'm page 24, my lord.
When have you filed it? Which paragraph have you stated?
My lord, 31st. No, yeah, I filed this. Sir, that I mentioned page 1, sir.
Which paragraph?
I'm coming to that, sir. Kindly come to page 4, my lord, para 5.
Where is the return of Form 30 you have filed?
Form 30, sir, I cannot file the return as such. Because unless they permit me to file the return, I cannot file the
Then
return.
you said that you have filed it with objection?
This audited balance sheet I have filed, sir. Audited balance sheet tax audit report I have filed.
Return has not filed, madam.
Where have you said that you have filed audited balance sheet? Which paragraph?
Audited page 24, my lord. Page
In
24.
which paragraph you have said that you have filed the audited balance sheet?
Page 24, para 3, my lord.
Which paragraph you have said that you have filed the audited balance sheet?
Petition page 4, para 5.
Audited balance sheet.
And copy of the application dated so and so and Form 30 are annexed.
Application, the audited balance sheet.
In the application, sir. In the application, my lord, I have mentioned that I have filed the balance sheet. This application is annexed, sir. Application at page 24, para 3, I have mentioned that I am filing this.
Just audited. But he has.
So it went to the board because it was more than 50 lakhs. Otherwise, the principal chief commissioner could have
Yes, my
decided.
lord. Yes.
Yes.
Yes, my lord.
This was decided beyond 6 months.
Was decided, my lord, yes,
Beyond 6 months.
beyond 6 months.
So your circular says that you are required to decide it within 6 months.
6 months, yes.
That is there.
But it was decided, my lord, just
On 30th of January 2024.
yes, 30th of January 2024. First time.
He made that application on 31st of March 2023. So you find faults with others.
But on 31st of March 2023, he has annexed that balance sheet along with the application. That is there in paragraph number 3, my lord. That application, the balance sheet has to be filed, my lord, much prior to that, but accounts are completed in, my lord, December 23rd December 2022 as per their submission, and my lord, thereafter, after
Tax
3
audit
months,
report is to be completed.
after 3 months, he has filed this along with this application, my lord. That is there. in
And tax
paragraph
audit
number
report
3.
is to be completed, my lord, after the statutory audit.
I will not go into the other issues, only with regard to 19(2)(b).
My lord,
Rest is for you to consider
my lord, my lord.
whether in the given facts he is
Yes, yes,
entitled
yes.
to refund or
That
not.
your lordship, that.
Anything else you want to add?
No, my lord. Nothing.
So the present writ application has been filed inter alia, challenging the order dated 31st of March 2024, whereby the petitioner's application for condonation of delay in filing returns under section 139 within bracket 1 of the Income Tax Act 1961 for the assessment year 2022-23 under section 119. Now here you have to refer to the said act. Hearing after to आगे हो गया. Under section 119 within bracket 2 of the said act has been rejected. Had been rejected. Has been rejected. So, such and such learned advocate representing the petitioner submits that the petitioner is an income tax payee and has paid and has filed its returns for the last 23 years without any delay. Now, and is regularly paying its and is regularly filing its income tax returns for the last 23 years. Full stop. It is a petitioner's case that the petitioner could not file its return under file its return of income under section 139 within bracket 1 and section 139 within bracket 4 of the said act for the assessment year 2022-23 for reasons beyond its control. Full stop. For reasons beyond control के लिए since the petitioner's senior accountant Mr. Arun Chatterjee was for reasons beyond its control. So, it is also the petitioner's case that the petitioner's senior accountant Mr. Arun Chatterjee had been diagnosed with heart ailments for which he had to be hospitalized and as such the books of accounts could not be finalized, which resulted in delayed filing of the returns. No, delayed finalization of the accounts. First, according to the petitioner, due to the deteriorating health of Mr. Chatterjee, comma, he had to resign from the company. Unfortunately for the petitioner, unfortunately, however, the petitioner could not find an immediate replacement. Since the aforesaid also resulted now, by reasons of the aforesaid, the petitioner was compelled to hold its AGM, was unable to hold its AGM within the time prescribed, and at the instance of the petitioner, the Register of Companies had granted extension for the petitioner to hold such EGM on or before 30th of September 2022. Insofar as filing of returns of income is concerned, the tax audit could not be completed within the time prescribed, and it is for such reason the petitioner had been compelled to apply before the Central Board of Direct Taxes, explaining the reasons for non-filing of the return within the time prescribed, and had sought for condonation of delay on the ground of genuine hardship. We hereinafter refer to board CBDT code. The board, however, by its order dated 31st of January 2024, was inter alia pleased to hold that the petitioner was inter alia pleased to observe that the petitioner had adopted a casual approach and took more than 3 months' time to find a suitable replacement for its accountant. Consequential enough, accountant full stop. The same, according to the board, constituted willful negligence on the part of the management and not genuine hardship, and in the facts as aforesaid, he refused to condone the delay. Mr. Such and such learned advocate represent the petitioner by placing the order dated 31st of January 2024, submits that the board ought not to have rejected the application for condonation of delay under section 119 within bracket 2 within bracket B of the said act, especially when by letter dated 28th of April 2023, and especially when, at the instance of the board, comma, by letter dated 28th April 2023, the Principal Chief Commissioner of Income Tax, West Bengal and Sikkim, had recommended condonation of delay in non-filing of return income, non-filing of return of income for the assessment year 2022-2023. He submits that there was nothing he submits that the finding reached by the board that the petitioner had adopted a casual approach is not based on no evidence. The finding reached by the board that the petitioner had adopted a casual approach and was willfully negligent was based on no evidence and is perverse. Full stop. The material placed before the board to establish genuine hardship was not considered.
Yes, my lord.
The impugned order is perverse and should be set aside.
My lord, I am grateful, my lord.
In support of his contention, he has placed reliance on a judgment delivered by the High Court of Judicature at Bombay in unreported judgment delivered by the High Court of Judicature at Bombay in WP number 4832 of 2021. ওই আগে বলেছি না সেট অ্যাসাইড বলেছি perverse and should be set aside. First of, he prays that necessary directions should also be issued, thereby condoning the delay in filing condoning the delay in terms of section 119 within bracket 2 within bracket B of the Senate.
My lord.
Judgment rely করেছে. Mr. Dudoria, learned advocate representing the respondents, enters appearance in the matter. He submits that in the facts of this case, the board had passed a discretionary order.
But also not that
discretionary order. That is your contention, obviously.
Yes, that is the, and also not my contention was section 119 2B says it has to be genuine hardship. That I had
discretionary order. Full stop. The petitioner had failed to demonstrate that the petitioner had suffered any genuine hardship. Full stop. As such, no interference in this case is called for. He, however, heard the learned advocates appearing for the respective parties and considered the materials and record system. Admittedly, in this case, now from the facts on record, it would transpire that the petitioner did not file its returns of income in time for the assessment year 2022-23. Full stop. It is also apparent from the records that the register of companies, taking into consideration the difficulties suffered by the difficulties of the petitioner in finalization of its accounts, had extended the period for holding AGM up to 30th of September 2022. Full stop. The illness of the petitioner's accountant the factum of the petitioner's accountant falling ill and subsequently resigning is not in dispute. Full stop. It would, however, appear not in dispute. Full stop. Although the petitioner had applied before the board by invoking the provisions of section 119 within bracket 2 within bracket B of the said act, praying for condonation of delay, the board, by interiorly observing as follows, the board, by interiorly observing as follows, had been pleased by interiorly observing and had been pleased to reject the said application by interiorly observing as follows, set out para 5.3, 5.2 and 5.3. First of all, to more fully appreciate the scope and object of section 119 within bracket 2 within bracket B of the said act, the same is extracted herein below. First of all, as would appear from the documents on record, that by a circular dated number 9 dated 9th June 2015, specific guidelines have been framed by the board for exercise of powers under section 119 within bracket 2 within bracket B of the said act.
My lord.
As would appear from the above, the application for condonation of delay was made within the maximum outer limit, within the maximum period prescribed, within the maximum period provided for seeking condonation of delay. admittedly in this case, the principal chief commissioner of income tax, admittedly in this case, in terms of a report called for by the board, the principal chief commissioner of income tax, West Bengal and Sikkim, had recommended condonation of delay in non-filing of returns of income for the assessment year 2022-2023. The board apparently has brushed aside the said recommendation without entering into, without disclosing, without identifying reasons as to why such recommendation has been ignored. Mr. Dudoria, learned advocate representing the respondents, has also not been able to identify any reason as to why the recommendation made by the Chief Principal Commissioner of Income Tax, West Bengal and Sikkim, as to why the recommendation made by Sikkim at the instance of the board had been overlooked. Full stop. It, however, appears that the board, by placing reliance on the case of Bhandari Nandgud Patil Associates versus CBDT, you are by placing reliance. By placing reliance on a judgment delivered by the Honorable Delhi High Court, in the case of such and such, has been pleased to observe that when the legislature has provided for time limits for certain obligations under the Act, and these time limits such time limits are required to be observed, in this context, it would be relevant to consider, relevant to take note of the judgment delivered by the Honorable High Court, by the Honorable High Court of Judicature of Bombay in WP number 4832 of 2021. In paragraph
page 13, my lord.
Roman 9, page,
Wait, sir.
9, page 13. Paragraph 13, page.
Paragraph 13 of the said judgment. The Honorable Court had been pleased to take note of the judgment delivered by the Delhi High Court in the case of B.U. Bhandari Nandgud Patil and Associates, Supra. The relevant portion is extracted herein below. From the aforesaid, it would be apparent and clear that The only question that is required to be decided is whether the assessee had a reasonable cause or not. Full stop. In the said case, the assessee could not show any magical exigency of any kind and had merely attempted to make out to pray for condonation of delay by attributing the delay on the auditor. Full stop. The present case is, however, entirely different. Admittedly, in this case, the auditor, the chief accountant, had initially fell ill and subsequently had to resign. Full stop. Although the board had observed that the petitioner had adopted a casual approach in finding out replacement for its accountant, and there is willful negligence on the part of the management, the materials on record do not substantiate the same. Full stop. To the aforesaid extent, the above finding reached by the board appears to be perverse, appears to be based on no evidence, and is perverse. Full stop. Ailing health of an accountant. Ailing health. Considering the entirety of the considering the genuinity of the petitioner's problem, which has not been disputed by the learned advocate. Shall I record this? Considering the genuinity of the petitioner's problem, now considering the enormity of the problem suffered by the petitioner, and the subsequent resignation of the petitioner's accountant due to his health condition, would certainly make out a case of genuine hardship. In view thereof, now having regard to the aforesaid, the order dated 31st of March, January 2024 cannot be sustained. The same is accordingly set aside. Since no fruitful purpose will be served by remanding the matter to the board for reconsideration of the aforesaid issue, I am of the view that delay in filing the return, I am of the view, considering the unavoidable circumstances and the genuine hardship suffered by the petitioner, the delay in filing the return by the petitioner should be condoned, especially when the petitioner had already where is that you have filed it?
But that is not an app, along with the application, that is not.
Especially when the petitioner
Page
in its
24.
application praying for condonation of delay
Page 24.
filed on 31st of March 2023 had enclosed therewith
Balance sheet, right.
where have you enclosed? Which paragraph you have said?
Paragraph 3.
Three, my lord.
Third paragraph. Audited balance sheet. Page 24, third paragraph.
Yes. The audited balance sheet copy of the audited balance sheet for the assessment year 2022-2023. So accordingly, the delay in filing of return under section 119 within bracket 2 within bracket T B of the said act is condoned, and the matter condoned with the liberty to the petitioner to file its returns on the portal.
Portal, it will be physical, my lord. Cannot be on.
File its return of income within a period of 15 days from the date.
We will do it.
Within a period of 15 days from date.
My lord.
Full stop. If such return is filed, the same shall be accepted by whom?
By the
Jurisdictional assessing officer.
Jurisdictional assessing officer.
Jurisdictional assessing officer, and the same shall be processed in accordance with law. So I made it clear that this court has not gone into the merits of the returns of income to be filed by the petitioner, and it shall be open to the assessing officer to deal with the same. To consider the same in accordance with law.
My lord,
With the above observations,
only
there are
one thing can be added: file to allow the petitioner to file the return of income along with the application for refund. Otherwise,
that I have not. If you are entitled to entitled.
Understood. My lord.
With the above observation directions, the application stands disposed of. They shall be notarized. হয়ে গেছে ডাকো এটা ডাকো সময় আছে এই তো জাজমেন্ট এই এফিডেভিট অফ সার্ভিসটা ঢুকিয়ে দিই
Item number 18.
My lord.
For the respondent.
My lord, very short issue is there. I was given time up to 22nd of March to file my reply to the show cause notice. That is at page 23. At 5 p.m. when I tried to upload the reply, I find that the portal is closed. So I had
your chance.
So my lord, I had no alternative. I rushed to the PCCIT. I said, what to do? He said, you see, you go file it to the Samadhan. They will forward it to ITO concerned. So immediately thereafter, my lord, I filed the entire thing to the portal of Samadhan, including copy to CBDT and everything. It was 22nd March. The ITO completed the assessment on 25th of March. And that Samadhan forwarded all the papers to the ITO on 26th March. And in this process, the ITO has made heavy additions. So my only prayer is that let this order be sent back to ITO to reconsider after my looking after my submissions.
Lordship will kindly have against the assessment order. Lordship will kindly have page 28, my lord. As he has come before your lordship against the assessment order, which is appealable. And my lord, it is not that he has participated in the proceedings. 142(1) notice, my lord. He has given his reply. He has submitted all the documents. That those are also considered. Lordship will kindly have a look at the order, my lord.
I will hear you.
Entire order.
My lord, this is my lord. This is the alternative remedy is there, but this is the violation of principles of natural justice. You give me the hearing and close the portal.
Oh, he has given you hearing,
but he has closed the portal so that I may not upload the reply. My lord,
At this point in the before the appellate authority.
my lord, when the alternative remedy is there, but if there is no efficacious remedy, here, my lord, how much addition has been made? 50 crores against the income of 1 crore only. So when that remedy will be available? Here, there is direct violation of principle of natural justice because the portal is closed and I've got the evidence for that. I've given the evidence for that. I have also uploaded my reply to the Samadhan, to the PCCIT, to the CBDT, everybody on that day itself, requesting you forward it.
You wait for the last date.
Last date was 22nd, sir, to file the reply. My lord.
When was the opportunity given to you to file reply?
My lord, originally it was, the opportunity was given on 11th March. Then I wanted extension because a lot of details are wanted. So he allowed me extension up to 22nd March. And I was ready on 22nd March. I uploaded everything. But since the portal was closed, I could not send it to him. I had to upload to the portal of the Samadhan, where my PCCIT directed. I also uploaded to the CVDT with a request to forward it to the ITO concerned. And they forwarded to 26th. So where was my fault, my lord? I have done to the best.
Back, I'll hear you.
My lord.
Back to. I'll conclude the matter. When was the order passed?
The order was assessment order was
25th March, my lord.
25th.
And my reply was forwarded 26th by Samadhan.
Order was passed not on 25th of March.
You have time for preferring appeals?
Not 45 days. From the
26th of
30
March.
days,
Time is
30
over.
days,
30 days. 30 days.
30
Yeah,
days.
long
Time is over.
Yes, yes. So long time. But he has
I have
filed.
not filed, my lord. My lord, I
was filed
On time after 1 month.
after. Yes, yes. But he has
My lord,
filed.
After 1 month, you have filed it.
my lord, the problem is that demand of
You file it after 1 month.
25th April he has filed.
My
He has
lord,
filed on 25th April. Affirmed on 25th.
30th of April, he has filed it. It has been filed after 1 month.
Yes.
Yes, check it. Check my records.
Yes, yes, yes.
Check my records. I'll come back at 2. Be here.
for some day.
No. Be here. I'll come back at 2.
My lord.
তাহলে জলপাইগুড়িটা ডেকে দাও, ডেকে দিও। Just wait, there is a জলপাইগুড়ি matter. I'll just call up and then I'll come back. It'll take 2 minutes time. Call out জলপাইগুড়ি দাও। ডাকো ডাকো, মুখে বলো না। মাইক্রোফোনে মাইক্রোফোনে মাইক্রোফোন।
Jalpaiguri matter, item number 1.
Yes,
Yes, your lordship.
yes, Mr.
Yes, your
Modi.
lordship.
Yes, Mr. Sir, you are there.
Yes, my lord. Am I audible, my lord?
Yes, yes, you are audible. You will remember that the matter.
My lord, I remember. My lord, I disposed of one of the 3 matters, and the 2 matters your lordship had taken back.
Since the matters may not be identical, so I had kept these 2 matters reserved. But difficulty, original records is not there. Where is the original records?
Original records of my lord.
These
Reading
2
them.
matters.
Original record of the court or the disciplinary procedure?
Entire disciplinary proceedings records.
My lord, would your lordship allow me to come back on Wednesday so I can inform your lordship about the
I'll just
where
issue. I'll just issue a direction, Mr. Mojumdar. Kindly produce the
Hello.
original disciplinary proceedings
Lordship.
records of this case.
Absolutely. my lord.
So that is the distinguishing feature in the matter. So I want to see the records.
There is a minor distinguishing factors, my lord. My lord is absolutely fine. My lord.
This matter has come for seeking certain clarifications. Full stop. It appears that the original records of the disciplinary proceedings have not been produced. Full stop. In view thereof, let the original records of the disciplinary proceedings be placed before this court. When you want it, Mr.
My
Mojumdar?
lord, if my lord doesn't find me amiss, my lord, there might be a problem with the technical issue of rule, my lord. We were under the impression that my lord has completed the hearing and my lord has reserved the order.
Hearing is completed. But you kindly produce the records.
My lord, I will, my lord, kindly give me some time. So today I can get in touch with the concerned department. And hopefully, my lord, within 4 or 5 days, we will be able to come before your lord. By this week, my lord. My lord, they kindly puts it on Tuesday because my lord, Monday is a holiday. I guess.
On Monday?
Monday is a holiday, my lord.
Tuesday?
Lordship.
Let this matter appear under the same equivalent. When the matter is taken up. Next, list this matter under the same heading for the purpose of production of original records, on original records of the disciplinary proceedings on 18th.
Tuesday is 18th month.
18th.
Grateful to you.
Yes.
With your leave, my lord.
Only to this, only the records you will hand over.
Lordship, am I permitted to withdraw, my lord?
Yes.
Permitted to leave, my lord.
I couldn't get you.
I am seeking your lordship's leave to get out of the virtual mode and go physical before the court.
Thank you.
Grateful, my lord.
Yes, Colin. Item number 2. Same.
Same matter.
Double.
Continue matter, item number 18.
My lord, maybe kind enough to pass it over because my man is going to bring the copy of certain judgments.
Whatever you want to place, yes, place it.
My lord.
Yes, sir.
My lord, this order was passed on 25th of March. My petition was ready on 25th of April. It has been affirmed on 25th of April. Only my junior could not file it. He could file it only
It is on 30th of March, April 2024. It has been filed.
Yes, my lord. Because
I can see it here.
Yes, my lord, I say. But what happened to Mr. Sengupta? His son's G entrance examination was there.
That is not pleaded in the petition, so I cannot look into that. Question is, sir, what was the issue? It will not make much of a difference. I am not going to dismiss your matter only on the ground that decided against you, only on the ground that it is filed beyond 1 month.
My lord.
But certainly, this will have a bearing whether this court will entertain this matter or not.
My
I am
lord.
not going to reject your claim.
My lord.
You have a statutory remedy, sir.
Yes, my lord.
You are saying that you did not get opportunity to file a response.
My lord, yes.
And
Because
then, I remember your facts. You say that you could not file your response despite being offered with an opportunity to file a response on the portal.
My lord.
Show me what proceedings this matter pertains to.
Yes, my lord.
There is an assessment order.
Yes, my lord.
Now, before the assessment order was passed, Proceedings under section 144 was initiated.
No, my lord. Only so cause.
Oh, this is 144B, so therefore faceless.
My lord.
This is faceless. Faceless
Yes,
proceeding.
yes, Lord,
একটা income tax
page number 9, Lordship.
হ্যাঁ ঠিক আছে
This is so cause notice, my lord.
Yes. Notice under section 143 was issued.
Notice under section 142 was issued, my lord.
Yes, 143, 142, one was issued.
That was issued, my lord.
You responded to that?
I responded to that, my lord.
Thereafter?
Thereafter, a so cause notice was issued, my lord, on 11/3/2024.
Where is that?
This is at page 9, my lord.
Page?
9.
Yes.
That is annexure P, page 9, 11/3/2024. This so cause notice was received, and I was to comply with this so cause notice by 18th of March.
The show cause why proposed variation shall not be made.
This so cause notice, my lord, is asked for certain things that these are to be explained and all that.
Well, how many days time has been given to
7
you?
days time was given to me, my lord.
That is the minimum time prescribed?
That is minimum time prescribed. There is no dispute. My lord, then I applied that since voluminous details have been asked for, kindly give me some more time. Then, my lord, he
Where have you
issued
stated
another
that?
letter at page 23. Page 23, he has given me time up to 22nd March 2024.
No, you responded to this notice.
Sir, I responded, then he has given.
Where is your response?
Request for time I wanted.
Where is your response?
Kindly see, my lord, page 23. That adjournment petition was there only.
No. Where is the show cause? Only show cause response.
Only show cause letter, my lord.
Very well.
Okay.
This proceeding is required to be completed within 1 year.
Yes, my lord, by 31st March.
By 31st of
March 2024.
Now you took time.
I took time, my lord.
Sought for an adjournment till 18th March.
Adjournment granted, my lord, by page 23. They have given me time up to 22nd March. Say request for time for upload documents.
22nd of March.
22nd March.
Yes. What is the office hours?
Office, my lord, in faceless actually up to 11:59 they accept.
That is different. Office hours is?
Office hours is from 10 to 6. Now, my lord, then even at 5 I wanted to upload. At 5. It is not that
Why
after
did you
office
wait
hours.
for the last moment, sir?
My lord, the problem is, my lord, volume.
Where have you said? Where have you said?
Kindly come to page 26, my lord. My petition to the Samadhan, PCC80 and CVDT, page 26. The lower portion, dear sir, the assessment of the above assessment is going on for the assessment 22-23, which is
Samadhan is 26th.
Samadhan has forwarded it on 26th. Before that, my lord will see below that from Assam Surana, and I have forwarded on 22nd March.
655.
Sir, my lord will kindly see the contents of the letter.
Yes, 655 hours.
Yes, my
This
lord
letter is 655.
Yes, I agree, my lord. Kindly, my lord will see my contents of my letter, what has transpired. The assessment of the above assessment is going on for assessment 22-23, which is time barred so and so date. The SSC was received so called notice on so and so date against.
Where is the screenshot of the portal? Where is the screenshot of the portal?
Yes, my lord. The folder.
Show me. Where is the screenshot?
It is at page 24, my lord.
Page
24.
Enclosure at page 24.
The feature of the screenshot is page 24. And my lord will kindly see, submit response that column is erased, that is freezed.
Where is the timestamp?
This time, my lord, is on the corner of this page. Actually, it is
I can't read
533. The 533, my lord. Is in the corner of this left-hand corner of this page, my lord. I'll give you a fresh one. Hold on, so hold on. Hold on. एक minute.
10 to 5. What is the working hour? 10 to 5.
5:36. 5:33, my lord.
It is there 10 to 5.
10 to 5.
Normal working hours, not.
Yes. Anything else?
My lord will kindly see what has happened. What I have mentioned in my letter. Kindly, my lord will see. Yes, however, while filing the reply along with the enclosures at around 5.
What is the outer limit for filing the appeal?
30 days, my lord. Within 30 days, he has to file. From the
He can also prefer a condemnation delay. Accept his appeal.
Lordship, Lordship will kindly pass on the order. Time to file appeal may be extended for a period of 1 week. Let them file appeal. We'll consider that.
I'll extend the time for filing of the appeal.
Yes.
My lord, the position, my lord, is that in first list they give time for compliance even up to 11:59 p.m. I can show a number of notices, my lord. And here,
This
my
matter
lord
does not aspire so much of confidence in your favor, sir.
My lord,
the other matter where I wanted
my lord,
where the matter required interference, I had interfered.
I wanted to apply it, my lord, at 5 p.m. It is not that I want.
No, it's 5:33. I've seen that.
That screenshot I have taken after consulting the PC, Principal Chief Commissioner, my lord. After consulting
the persons who are looking after these matters,
my lord,
are
even
smart people.
My lord, even people do not know where to respond if the portal is closed. So we have to make the inquiry. And my lord, just see.
Two notices and proceedings.
Sir, nothing is.
There are two portals. There are two phases. One is the view notices, and the other is
to reply. That's all. To reply, that is open.
No, there is another.
No other
place
choice. There is no other choice, my lord.
One is the view notices. There is another place.
So
another matter I've dealt with.
Grievance.
Grievance.
Before the grievance.
Income tax, that is not there. That is
GST. That is GST.
That is GST. I am not dealing GST, so I do not know. GST portal.
You prefer an appeal? I'll give you that opportunity.
My lord, kindly.
And I will provide. The appellate authority will consider all these issues.
Yes.
My lord, if it can be done that if the SSC files the appeal within 30 days, the CIT appeal will dispose of within 6 months.
I will provide for that. I'll provide for that.
That
also.
That will do, my lord.
Also.
That will do. Yes. if the CIT
yes,
because otherwise there are, my lord, I have
no, I'll also provide for that. You see, difficulties in this matter. You have given notices. 142. This notice has been also been issued.
His reply was also considered. He has given his reply.
No, my reply is not considered, my lord.
I'm not going to that.
Yes.
I will not go into that.
No. You also not.
This Shoka, I mean, now show me the pleadings. Now come to the pleadings. Before I record all this, where are your pleadings? Show me.
My petition ne bola, sir.
Yes.
I am just showing. Kindly see, my lord. And I think
Paragraph 8, lordship.
Paragraph 8 and onwards, my lord. Paragraph 8. Your petitioner states that it prepared the reply to Suko's notice along with all documentary evidences by 5 p.m. on 22/3/2024. However, when it was being logged into the income tax portal, electronically furnished the reply, it was found that the option to submit the reply has been closed. The petitioner was unable to file the reply. The petitioner has downloaded the screenshot. Thereafter, your petitioner left with no alternative but to immediately send to grievance at 6:54 p.m. And my lord, the problem was that grievance has forwarded that all the papers on 26th. They should have forwarded then and there.
This is reassessment.
No reassessment.
No,
regular assessment, my lord.
Assessment.
Actually, my lord, I have been denied natural justice, my lord. That much I can say. Because
it was a preliminary inquiry before assessment.
My lord, final so called notice was issued on.
You are given notice under section 142(1).
Yes, my lord, but these documents are required only here.
Why?
Because in the so called he said that you submit this. Certain things you prove this, you prove this, you prove this. Number of.
You show me that this was not called for earlier.
No, those are everything.
Show me that is his case.
No, Lordship
Show me your notice under section 142.
Here's not annexed.
Not enclosed.
You have a copy of the 142 notice. Ask your junior.
Not my lord, not my lord.
Here's not annexed those documents.
Because I have seen his reply.
Yes.
What prejudice you have caused, you have to also show me that.
Sir, my lord, because my reply which I was filing on 22nd and which has been uploaded to him by the Samadhan on 26th. Because it is Samadhan, he has made the mistake that they uploaded.
No, where is your response?
My lord,
where is your response?
That response.
Where is your response?
That on 22nd, which response I wanted to give.
Yes, where is that?
My lord, I will file a supplementary.
Oh, sorry, sir. You have not even disclosed the response. Brilliant.
My lord, because the issue was simple that let him consider my response. That was the issue.
Where is that response?
I agree, my lord. I'll give a supplementary affidavit, my lord.
No.
Because I simply said.
Where is that response? Tell me where is. I want to compare both your responses and find out.
My lord, I have mentioned it that I have responded it. I have uploaded everything on Samadhan portal.
Sir, where is that? Where is that? What is your response?
My lord, it is not enclosed.
To High Court, sir.
It should have been.
Yeah, extraordinary remedy.
It should have been enclosed along with the affidavit itself, my lord.
Ashun. The present writ application has been. I'll give you liberty. Go there. I'm not prejudicing. You will not be prejudiced by this order.
No, I do.
Because at the end of the day, no point keeping these matters alive, sir.
The only problem is, my lord, that for 8 years, 10 years.
Then you ought to have shown this court what was the previous reply and was the subsequent reply which the court was required to be considered. You have not even disclosed that. There is no pleading, sir. Nothing. I'm ignoring that very well. You have not pleaded. I'm ignoring that.
It should have been enclosed with the writ.
At least you have annexed the document. The document is also not here. How are you prejudiced? You have been unable to demonstrate that.
I agree, my lord. It was a mistake.
Very well. The present writ application has been filed inter alia challenging an order of assessment. Dated 25th of March 2024. March 2024. Passed under section 143 within bracket 3 of the Income Tax Act 1961, hereinafter referred to the said act, read with section 144 within bracket 9. Section 144 capital B of the said act. Poster. Records reveal that the aforesaid order was preceded by a notice under section 142 under section 142 within bracket 1 of the said act dated 2nd January 2023. Full stop. The petitioner had duly responded to the said notice by communication in writing dated 22nd of December 2023. Full stop. Following the aforesaid, a so-cause notice now 143 to 142(1) of the said act was issued.
I may point out one thing only.
In respect of Yes.
I may point out one thing.
Yes, yes.
The additions are made on two heads, loans and creditors. Those details were there before.
I'll not go into that at all. I'll not go into that at all. I'll keep it open for you. So that any observation made by the court will influence either way. In respect of the assessment year, in respect of the returned income for the assessment, in respect of the returned income for the company of the petitioner for the assessment year
22-23.
2020.
Twenty 2023. Where is that date?
Your lordship file, my lord, page number 28, assessment year.
Yes.
Page number 28 of my
Serial number 4.
332. 1. কি বলেছো preceded by notice? না 143 প্রথমে 143 2 of the said act. No. Said act. Said act. On 2nd June 2023, full stop. The same was followed up. Now, it is not in dispute that subsequently notice under section 142 within bracket 1 of the said act was issued on 2nd November 2023 as also on 14th of December 2023. Full stop. The petitioner responded to both the aforesaid notices. Full stop. Subsequently, the jurisdictional officer, no, assessing officer, jurisdiction, yes,
not jurisdiction,
assessing officer.
Assessing officer.
Assessing officer had issued a show cause notice dated 11th of March 2024 for the assessment year 2022-2023 as to why the proposed variation should not be made. Particulars of the proposed variation were duly indicated in the said show cause notice.
That is there.
It is not in dispute. No, for indicated. Full stop. As would appear from the aforesaid show cause notice, the petitioner was offered opportunity to respond to the same
by 18.3, my lord. At page 21.
Page 21, lordship. Kindly submit your response to email by
at 11.
Page?
Page 21.
No, not 21.
Page 21, bottom, my lord. 3.4.11.
Yes. Opportunity to respond to the same by either accepting the proposed variation or in the alternative filing his written response objecting to the same on or before 18th of March 2024. It is not in dispute that the petitioner on 18th of March 2024, March 2024, instead of filing his response to the show cause, had sought for an adjournment Full stop. By an order dated 19th of March 2024, the assessing officer, taking into consideration the fact that the matter would get time barred, had granted opportunity to the petitioner to respond to the show cause dated 11th of March 2023, latest by 22nd of March 2024. Full stop. The petitioner contends that on 22nd March 2024, although the petitioner had attempted to upload the documents, upload its response along with additional documents at around 5:33 hours, 17:33 hours.
That was the screenshot taken, my lord.
That is the time.
Yeah, that is the time.
The portal did not permit the petitioner to upload the response, as the submit response button had been deactivated. It is in such circumstances that the petitioner, on 22nd March 2024, at around 18:55.48 hours, had uploaded the same to the grievance, to the
Four persons, my lord.
to the Samadhan
Yes.
portal, to the separate portal.
Yes, my lord.
Samadhan is a separate portal.
Separate portal.
To the Samadhan portal, lodging a complaint in that regard. Mr. Such and such, learned advocate, by placing reliance on the communication dated, on the email communication dated 26th of March 2024, appearing at page 26 of the said petition, submits that the Samadhan portal had forwarded the petitioner's response to the assessing officer only on 26 March 2024 at 11:55 a.m. and the assessment order itself was uploaded on 26th of November, 25th of, it was uploaded when?
On 25th of March, sir. I am not getting the time, my lord.
Uploaded on 25th March 2024. As such, the assessment officer, without considering the petitioner's response, had disposed of the said proceedings. This, according to the petitioner, has the effect. Now, this, according to the petitioner, has the effect of vitiating the proceedings, as the petitioner had been denied the opportunity to respond. It is submitted that this court may be pleased to set aside the assessment order and to remand back the matter to the assessing officer for redetermination of the issue on the basis of the response filed by the petitioner. Mr. Dudoria, learned advocate, representing the respondent, submits the assessment order which has been called in question is an appealable order. Admittedly, the writ application has been filed beyond 30 days from the date of passing such order. As such, the petition has been filed beyond the prescribed, beyond 30 days from the date of passing of such order. Ordinarily, if an appeal was filed, ordinarily, time to file an appeal from an order of assessment passed under section 140 passed under section
142.
143 within bracket 3 read with section 144 capital B of the said act is 30 days.
30 days.
Full stop. There is no explanation for the delay in filing the appeal. There is no explanation for the delay in filing the writ application. So in any event, this writ application should be dismissed on the ground of alternative remedy. Full stop. He further submits that in any event line. He further submits that no explanation has also been offered by the petitioner as to what prejudice the petitioner has suffered by reasons of non-consideration of the petitioner's reply. First, last line that
And also,
dismiss.
my lord, that reply has not been annexed. That your lord.
That you did not point out.
Yeah, sure. Well, well.
Are the learned advocates appearing for the respective parties and consider the materials on record? Full stop. In this case, it is noticed that the petitioner challenges an order passed under section 143 within bracket 3 of the said act read with section 144. 144 within bracket 3 read with section 144 capital B of the said act dated 25th of March 2024. Full stop. Admittedly, prior to issuance of the aforesaid order, notices under section 143 within bracket 2 and 142(1) of the said act had been issued. The petitioner had duly responded to the same. In this case, the petitioner was well aware that time to complete the proceedings was about to expire on 31st of March 2024. Notwithstanding the aforesaid, the petitioner, instead of responding to the notice dated 11th of March 2024, had sought for an adjournment on 18th of March 2024. First up, at the instance of the petitioner, time to file the response was extended till 22nd of March 2024. Full stop. From the documents on record, it would appear that the petitioner had attempted to file its response after 5 p.m. on 22nd of March 2024. That is beyond the office hours. Full stop. It, however, full stop. The communication made by the petitioner to the Samadhan portal also does not disclose the copy of the response filed by the petitioner with the Samadhan portal. Now, from the has also not been disclosed in the present proceedings. Full stop. The petitioner has failed to identify what prejudice was caused to the petitioner by reasons of the assessing officer not considering its reply, and now whether the reply submitted by the petitioner was different from the previous replies submitted by the petitioner to the notice issued under section 143(2) of the said act. Full stop. Admittedly, in this case, now it would appear that the order passed under section 143(3) read with section 144(b) of the said act is an appealable order. Having regard to the aforesaid, and since the petitioner has having regard to this said act, stop. Although the petitioner has attempted to make out a case of violation of principles of natural justice, in absence of the petitioner being able to demonstrate the prejudice caused, I am of the view that the petitioner is not entitled to relief I'm of the view that the petitioner cannot be entitled to maintain the writ application before this court. No, maintain no lawsuit. I'm of the view that the petitioner cannot be entitled to relief as prayed for. Full stop. However, taking into consideration the fact that an appellate forum is available, efficacious appellate forum is available, I am of the view that justice would be subserved if the petitioner is granted liberty to file an appeal from the order dated 25th of March 2024 within 2024, full stop. If such appeal is filed within a period of 15 days from date, the same shall be heard and disposed of 15 days from date, along with an application for condonation of delay. The assessing officer, upon condoning the delay, shall hear out and dispose of the assessing officer, no, the appellate authority, upon condoning the delay, shall hear out and dispose of the appeal on merits, as expeditious on merits, taking into consideration the response given by the petitioner and the ground raised by the petitioner in appeal within a period of preferably within a period of 6 months from the date of filing of the appeal. 6 months from the date of filing of the appeal, subject to compliance of other formalities by the petitioner.
Grateful.
In accordance with the observation and directions, the application stands disposed of.
Since the affidavits are not called for all the allegations.
Nothing is there. Affidavit of
Grateful, Lordship.
আরেকটা ডাকো, আরেকটা ডাকো, তিনটে অব্দি অরিজিনাল সাইড আছে। ডাকো ডাকো ডাকো।
Item number 19.
Lordship, I am for the petitioner. I'm filing affidavit of service.
What is the matter?
Lordship, this matter is pertain to cancellation of GST. The petitioner is a proprietor.
Cancellation of
GST number.
Registration. Yes, you have to be there. You are a necessary party. In your absence, matter cannot be decided. You've served. Serve him tomorrow.
GP অফিস একটা সার্ভিস করে দেবে স্যার। এটা কত 19?
Yes, yes, point number 4. Keep it with you. Keep it. Tomorrow or day after? No, if there is anything else, then you take into consideration ordinary case or special case.
State, it's a commissioner of CG.
I dismissed on the ground barred by limitation. I'll decide it.
Just go through his report. Central government is answering this one.
CGST লেখা আছে, CGST.
State of West Bengal is also a party.
We will be there.
He is agreed by the order passed under section 107 of the said act, refusing to condone the delay. But I will hear out the main matter. Appeal has been dismissed as time barred. So I have to hear out the matter.
But state, I think he should serve a notice again upon the
Central government. এটা এখানে
Monday, serve once again.
because they are the answering this one.
Monday. An order দেবে না কোনো, শুধু not this week হবে। Sir, these will appear at the top. It will continue to appear in the monthly list.
Item number 20.
Yes, Mr. Mojumdar. Under Delay of if they are still having that same point.
But we want, my lord, all these matters should be heard because your lordship has fixed the matter with regard to that condonation of delay.
Then I have to, once I condone the delay, then I will hear out your matter also.
That is what.
No, the main matter also. Otherwise, send it back to the authorities. Why will this court be burdened with these matters? I'll send it back to the authorities. Then you see, the floodgate will open if this court starts taking up these matters. Unless in a particular matter, Mr. Siddiqui, you say, this matter delay should not be condoned. Look at this conduct. Conduct is so bad. Here, you've seen the order. See the order. Come to the order. Yes. See the order. What is the observation made in the order?
I've seen that. He has annexed the certificates also.
And also, kindly see the last paragraph, the proviso subsection 127 makes it crystal clear that he has no power to allow the appeal.
That's the line difficulty. Tomorrow at the top, first matter.
He has decided division will of
I kindly say.
my lord has power to pass the order.
Copy lagna.
No, you cannot question this today. You have to go before the Honorable Supreme Court. S.K. Chakravarti Division Bench.
Well, we have preferred in this.
Naturally, you are taken note of that.
He has been granted by the Supreme Court, cannot operate as a stay of the.
ঠিক আছে আমরা বলছি না আমরা জানিয়ে দিলাম এসএলপি করে আমি বলেছি ওটা বাইন্ডিং আছে
সেম লাইনে করব
করছে
order dated
Order.
No, the original order is no, impugned order is 4th October. What is that order? What is that order? Where is that? Where is that? Where is that?
Page 27 minutes.
Page 27 31. Start from page 28, 27 and
এসি চলছে না এক্সট্রিম গরম লাগছে এই দেখো না এই এসির লোকটাকে কি হলো ডাকলে না চলছে এসি গুলো এখন ডেকে পড়ো শীতকালে বেশি বেশি চালিয়ে রেখে দেয় গরমকালে এখন বুঝতে পারছি না This is not working at all.
It is not at all.
আমি ডাকো না খবর দাও তো আমি বুঝতে পারছি He's of the view that it's working, but because of the high humidity, we are unable to appreciate that the AC has been switched on properly. Is working. Yes, you agree by the summary of this order. This is under section 73. 27 is 3, separate order. 27 is 3, 73. How come this becomes 74? This is yes, so that's why I'm asking 73 or 74?
73.
Oh, that's what I'm asking. You are saying 74.
That is 4th October 2020.
Very well, it's all right. When did you file the appeal?
27th February 2024.
I come to page 35.
Just a minute. Yes, APL 0. This const 33,296, 10%.
Yes, my lord. Well, kindly see the page 36. The
Same
amount
that
is
is-
mentioned is 3,32,942 is the amount, tax amount.
আচ্ছা এখানে চেঞ্জ করতে হবে বলে দিচ্ছি এখানে আছে আলাদা একটা আলাদা আছে Present writ petition has been filed inter alia questioning the purported rejection of the appeal filed under section 107 of the GST Act 2017 herein after referred to said act vide GST APL-02 dated 28th of March 2024. Full stop. Mr. Mozumdar, learned advocate, comma, Age comma, Mr. Mozumdar, comma, learned advocate, appearing for the petitioner, submits that being aggrieved by the order dated 4th October 2023, passed under section 73 within bracket 9 of the said act, comma, the petitioner had filed an appeal on 27 February 2024, comma, as would appear from GST APL-01, full stop. Paragraph. By drawing attention of this court to page 35 of the writ petition, it is submitted that when the aforesaid appeal was filed, along with 10% pre-deposit of the disputed amount of tax, a system-generated provisional acknowledgement form as proof of submission of appeal was issued. Did you appear before the authorities?
Before the appellate authority, I appeared. But before the adjudication authority, we did not appear.
Before the appellate authority, you appeared.
Yeah, this is
Appellate authority, you appeared.
No, this is the ex parte order. This order of 28th March 2024
is an ex parte
is
order. So you did not appear.
No.
But
we have filed an application for condonation of delay. Well, kindly find page 49, paragraph, third paragraph. We have filed
46 is what?
46, my lord, this is my...
Is there a communication?
This is notice, my lord.
Subsequently on 14th of... This is received.
Yes, my lord. I have
Thereafter, you filed the application for
application of condonation of delay.
Subsequently, on 14th of March 2024, the petitioner received a notice.
An application for condonation of delay we have filed along with the appeal.
And
then they have issued the show cause notice on 14th March 2024. And order passed on 20th March 2024.
So where is your application for condonation delay?
Well, this is... We have annexed, my lord.
Where is your application for condonation delay?
Page 41, my lord.
এই লাইনটা ঠিক আগে হবে।
Page 41.
এই ঠিক আগে was issued. The said appeal was also accompanied by an application for condonation of delay. First of all, according to the petitioner, there was a delay of 55 days in preferring the appeal. Mr. Mojumdar, learned advocate, আগেই বলেছি বলা আছে না এবার হ্যাঁ subsequently আছে হ্যাঁ subsequently on 14 March 2024 a show cause notice was issued calling about the show cause notice was issued as to why the appeal should not be rejected due to delay, as the same was filed beyond the prescribed period as provided for in section 107 within bracket 1, read with section 107 within bracket 4 of the said act. Full stop. In response to the above, the petitioner had represented before the authority.
We have not filed any response, my lord.
Did you appear before the authority?
No, no, my lord.
Full stop. The same was followed by the order dated 28th of March 2024. Full stop. Mr. Mujumdar, by drawing attention of this court to the order impugned, submits that the appellate authority by ignoring the explanation given by the petitioner and by placing reliance on the proviso to subsection 4 of section 107 of the said act, appellate authority has returned a clear finding that there is no power vested with the appellate authority to allow the appeal beyond the prescribed period of 1 month. Beyond the prescribed period of 1 month, or submission ঠিক করে দিই এখানে ল্যাঙ্গুয়েজটা তা নয়, beyond the prescribed period of 1 month as provided for prescribed period of 1 month মানে কি ছিল 3 months না? 3 months is 3 months.
Then 1 month.
Beyond the prescribed period of 3 months, beyond the prescribed period of 3 months or 6 months from the date of filing.
My lord, 6 months is different from the, in case of department, my lord.
Department.
But 3 months and 1 month. Condone the 1 month, the discretion of the authority concerned, they can condone the delay.
Yes.
Only 1 month.
Beyond the prescribed period of 1 month from the period of 3 months or from the period of 3 months.
After the period of 3 months.
After the period of 3 months. Full stop. According to the petitioner has not only a statutory right to prefer an appeal, but also has a right to seek condonation of delay in preferring the appeal. Full stop. It would be apparent and clear from the above order that the appellate authority had failed to exercise jurisdiction vested in him, while rejecting the appeal solely on the ground that it does not have the competence to condone the appeal beyond the time prescribed. First of all, Mr. Siddiqui, learned advocate, enters appearance on behalf of the state and opposes the petition. Anything else on this? He submits that since the statute recognizes, since the statute itself provides for the period for which delay can be condoned, comma, there is no irregularity on the part of the appellate authority in refusing to condone the delay beyond the period of 3 months from the time prescribed. First of all, heard the learned advocates appearing for the respective parties and considered the materials and record. Admittedly, in this case, would appear that the appeal had been dismissed solely on the ground that the same had been filed beyond 1 month from the prescribed period, beyond 1 month after 3 months from the prescribed period of submission of appeal. Full stop. Admittedly, therefore, the appeal was the appeal was obviously barred by limitation. Full stop. However, at the same time, the aforesaid could not have prevented the petitioner from maintaining an application for condonation of delay by invoking the provisions of Section 5 of the Limitation Act 1963. Full stop. হ্যাঁ এসছে, দেখো না।
But by the has already decided by the division bench of this honorable court is of case in Chakraborty and Sons versus Union of India and others. 3. SCC online Calcutta 47559.
Yes, ma'am. Yes, ma'am.
Having regard to the opposite, I am of the view that the applicant of the taken note of the application filed under section 5 of the Education Act. Taken note of the application for protection of the filed under section 5 of the Education Act 1963. Since the opposite appeal, having regard to the opposite, while setting aside the order of rejection of appeal,
March 2024.
appearing
APL 02 money. APL 02. What is it?
fact that no purpose is served. And what is the clear sentence? By remanding the opposite matter on the issue of confirmation of the appellate authority. Or else I'll send it to the authority.
Well, kindly make it con. It's only 25 days delay, my lord. Well, kindly appreciate the our division bench has decided the issue. Well,
Matter I have not.
This, that matter, that is different. No, that matter is different because in that matter I have not filed any application for continuation of delay. My lord has given the liberty to file a delay application.
And it could be.
And did you know of the explanation given by the petitioner?
ছোট একটা amount.
That the petitioner has been able to sufficiently explain the delay. Finding is sufficiently. Sufficiently. So having regard to the above, I direct the affidavit of certificate. Having regard to the above. Direct the affidavit of clear out and dispose the said appeal. Original file and number and direct the affidavit of
Yes, ma'am.
clear out the said. From the date.
Great.
2 months.
Grateful. Grateful, man. My lord,
Original sign, my lord, seeking. Lord, next matter 21.
হবে না
item number 21. No, my lord, only thing is the item number 21. My lord, learned friend is appearing. My lord, he is saying that he will
shall
take
be
the
taking the-
instruction. My lord.
We
That
shall be taking time. Next item 21. We come tomorrow. Tomorrow.
Great.
হ্যাঁ জানিস You are there? ফোকাসটা দিয়েছে বলে ওখানে থাকছে না
ওটা ওয়েট করেছি দুটো প্লেয়ার একসঙ্গে
Any mentioning original side?
May I have you kind leave to mention a matter, my lord, upon notice, my lord, for inclusion in your lordship. It was filed just before closure of court, my lord. No, my lord, it was filed, motion. Court application. হ্যাঁ সেটা বলছি my lord, it would have come in the usual course. We know, my lord, there was an urgency. That is why we were mentioning. If it could be any day convenient to your lordship. No, it has to be first listed and then taken up serially.
All this.
It's a revenue. Yes. Part 2. Yeah, of course it will. No, since your lordship takes it up from 3 o'clock, because there was an Now, I'll tell you, Lordship, why this matter. There was an urgency. This matter has a checkered past. There has been 2 rounds already. Wait. Very.
My lord, I am seeking my lord's very kind leave to mention 2 income tax matters. I will tell my lords what the urgency is. These are writ matters which had been admitted last year in June. The affidavits have not yet been exchanged. We had written to the department council in the month of November as well, and I have been in constant touch. The only reason why I had tried my luck prior to the vacations, my lord. I must be candid, but my lord had asked me to come after the vacations. The only urgency in these matters is that I am a microfinance company. Assessment orders have been framed where a demand cumulatively of about 10 CR has been raised. Appeals have been filed. Those appeals are pending. We have written to the appellate authority. The appeals are not being disposed of. In the meantime, we have deposited. My lords, I am humbly requesting that an early date be fixed and the department may be directed to file their opposition, because what is happening is that my lords may only give me 20 seconds. My lords, my lords, what has also happened, that is one of the prayers that I have. What has happened, my lords, is that while filing an appeal, I have to deposit 20% of the tax. In this case, admittedly, 100% of the tax has been taken by the department, and I am out of pocket of about 9 CR, my lord. And I'm a very small microfinance company. And this has been going on for over a year and a half. My lords, one of my prayers. My lords, what has happened is, my lords, I have annexed copies of those circulars. Initially, the circular spoke of 15%, which was raised to 20%. We had deposited 20%. After depositing of 20% for assessment year 12-13, I am to receive refunds which are undisputedly receivable by me, which has been adjusted. So I am left high and dry. My entire demand, my lord, in my most humble and respectful submission before my lord, is now with the department, and I am high and dry, my lords. My lords. My lords. My lords, I am grateful. I have done so, my lord, unsuccessfully. My appeals are pending. I bow down, my lords. What has happened is that the CBDT circular requires a deposit of 20%. The department, which I have already given, if my lord, if I may humbly submit, what has happened is that the CBDT circular, my lords, sure. My lords, it has been 10 months. My lord, in my most humble submission, I don't think there is anything that can be filed, because there is no dispute insofar as the facts is concerned. I will beseech my lords to take a very serious view of the matter, where I am to deposit 20. I have already done that. They have taken another 80. That is what has happened. My lord may only give me 30 seconds. What has happened is that over and above the 20%. Oh, yes, my lord. This is a copy of my notice. My learned friend was here, Mr. Aryog Dutt. My learned friend is here.
That kindly see this. We have filed an affidavit. He had asked him to deposit 20%, and he deposited.
I have done it, my lord.
Thereafter, when he did not deposit the money,
we color took the entire and that is we took the money that
Entire money is what my learned friend is saying. Entire money, my lord. My lord. My lord, my lord.
balance entire balance. Okay. And thereafter, he said that I am depositing 20%. Because the money was refundable to him. From there, he adjusted. There we adjusted. How much we adjusted? That
100%.
Yes, filed the affidavit.
My lord, we have not received any affidavit. I'm instructed. We have not received any affidavit. WPO.
Yes, absolutely. Authority, I cannot ask, but has been made. Now, what are you waiting for? Let the affidavit decide. Absolutely, I will decide.
I am extremely grateful to my lord.
Item number 1.
As I am for the petitioner, my lords. As on the last occasion, this matter was disposed of. My lords, it's appearing for to be mentioned. 21st May. That is appearing for corrections, my lords.
Order correction. Order correction বলে কি দিতে হবে? এবারে পুরো ব্যাপারটা। Not on application.
Deeply obliged. Deeply obliged.
Item number 2.
Next month.
Your Lordship, the advocate on record for this matter, Srijoni Mukherjee, has met with an unfortunate accident. Yes, she has been Srijoni Mukherjee. I've been instructed to ask leave and kindly keep this matter in any time next week. If you could, please. She met with an accident and she has been hospitalized. That is, yes. Anytime next week would be fine.
Before vacation, they have prayed time. Before vacation. That's why your lordship is saying next month. I am also next month.
Thank you.
Item number 3.
Thank you, no, my lord. Deeply obliged.
May it please your lordship, my lord. I am appearing for the petitioner in the matter. Supplementary.
Before I start, my lord, may I have my lord's kind leave to file a supplementary affidavit, which I'll be placing reliance on. But we have already served it on the respondents. But I'm praying for a leave, my lord. This is on the last day. The reason I'll indicate, when I had made a submission, your lordship will be pleased to recall this is just before the vacation. The reason for my lord, my praying for this leave, I'll indicate it's not required also. The supplementary affidavit, very well, my lord. The first reason, my lord, I'll not. That's for it, my lord. That supplementary affidavit, my lord. This is that 13th May 2024. So that was a development after filing of the writ petition. For that, my lord, the supplementary was necessitated. That we have filed. This, my lord, on the last day when we were making our submissions, an issue came up. I was showing, my lord, an assessment order which is a part of the, my lord, writ petition. The name did not match of the petitioner and the name in the assessment order. I could not immediately, my lord, place before your lordship where is the pleading and how the name is different, because my basis of my entire case is that order. So, my lord, your lordship had directed that you file a supplementary affidavit explaining how the name is the same. But perhaps that is not required now because the pleading is there. And I'll indicate from the records in the petition. If it is required, then I'll pay for the, my lord, leave. Otherwise, it is not required, my lord. My lord, I'm challenging an order which is passed under section 119(2)(b) of the Income Tax Act. The facts are thus, my lord. 2005-06, my lord, the petitioner had prayed for an opportunity, my lord, to develop a steel plant. They had to participate in a coal. I'll indicate. 119(2)(b), my lord, the grounds are this. I'm only aggrieved by that, my lord. The reason, my lord, is a background is required. Otherwise, my lord, a factual background. Order of rejection under 119(2)(b). No, I could not. No, it's not, my lord, a case of filing of returns. It's a case where, my lord, a joint venture was given a work. A coal block was, my lord, given to a joint venture. 3 entities in the joint venture, my lord. Kesoram Industries, Maharashtra Seamless, and the petitioner before your lordship. A bank guarantee was required for this joint venture. The name of the joint venture is Gondkari Coal Mines Limited, GCML. Now, my lord, total bank guarantee which was required for this work to be proceeded with was 11.88 crores. The 2 other partners of the joint venture made this payment by a bank guarantee. For us, the petitioner, my lord, we gave fixed deposit receipts, FDR. Our share was 2.88 crores, so our share was given as FDR. Now, this was not from our original funds, it was from borrowed funds, so it was not to reduce our capital exposure. We gave that amount, 2.88 crores. Now, the entire issue is, from this, my lord, there is a TDS, which was deducted. Income generated, my lord, TDS deducted. TDS was deducted. We always knew, my lord, it will be deducted and we can claim the amount because it will be reflected in 26 As. This was deducted and the department had the reflection in the name of the joint venture. GCML, that's the joint venture, my lord. It was in the name of GCML that the TDS was reflected in 26 As. When we, my lord, finally knew this, we could not have known this, that we will not be given the benefit. We were always under the impression that we will be given the benefit because that was also the arrangement. It is only when we were refused, my lord, an opportunity, it was on that refusal, we had the first opportunity. This was for 4 years. My lord, may I only request your lordship, there are 2 paragraphs. No, my lord, this is something very different because this is where for condonation of filing of return, my lord, this is not a case of filing of return. That's 6 years, my lord, that's 119. This is not refund, my lord. This is a claim of TDS. It's not refund. No, my lord, that's not the case. Refund and TDS, my lord, our case made out in the petition, kindly take up 2 paragraphs at page 6, paragraph 9 and 10. That's my case. That's because, my lord, kindly take up paragraph 9 and 10. I'll come to that, my lord. Yes, my application, my lord. I'll tell you. My lord. My lord, I will. Your lordship is taken up, my lord. There are 3 orders. There are 4 orders, my lord, in total. Because 4 different assessment years, 4 orders under 120. Kindly take up the first order. That's page 127. The second is 130. That's the second order, my lord. Same order for different periods. Petitioner Dhariwal Power and Alloys Private Limited has filed a petition for condonation of delay under 1192B of the Income Tax Act for delayed claim of refund of 3,78,000 for assessment year 2020-21. Petitioner is a company. Petitioner has stated that it has applied for, my lord, kindly see the next paragraph. It's not really a refund. That is where, my lord, they have gone wrong. Kindly see, my lord, has applied for credit of TDS which was deducted in the name of Gonkari Coal Mines Limited. That is the JV. Delhi for a joint venture of Dhariwal Power and Alloys Private Limited along with 2 other companies for the assessment year 2020-21. Report was called from the AO, that is ITO Ward 10-2 Kolkata, via a letter dated this. The assessing officer has submitted his report through a range by a letter of June 2023. AO reported that on going through the application of the SSC company, it is observed that Dhariwal Power, that's the petitioner before your lordship, had applied for credit of TDS, which was deducted in the name of GCML. That's my case, my lord. GCML, a joint venture company for the assessment year 2020-2021. Jurisdiction of the said GCML is presently lying with Ward 10-1 Delhi. In this context, the jurisdiction of Gonkari Delhi, PAN number this, is not lying with the charge. It is not ascertainable that GCML has filed its return or not. It is not ascertainable as that how the TDS of GCML will be credited in the PAN of the applicant. I pause here for a moment. This, my lord, is the very basis of my present petition, because this is completely against their own finding, which your lordship will find at, my lord, page 44 of the petition. Kindly take this in conjunction with page 44, because page 44 is their order. My lord. My lord, company before your lordship is Dhariwal Power and Alloys Private Limited. Now, my lord, before I state any further, kindly take up once, my lord, page 20. Unfortunately, this is where we had missed out on the last day. The reason I'll indicate to your lordship, page 20, the last paragraph. Kindly do not go by the petition, my lord. It is very evident, my lord, that this is not our draft with so many judgments included in the body of the petition. And that is where, my lord, we missed out at page 20, last paragraph, my lord. It may be noted that the petitioners were originally named as Dhariwal Infrastructure Private Limited, DIPL, which was subsequently changed after demerger order of the High Court as Dhariwal Power and Alloys Private Limited. Now, my lord, this is the reason of the supplementary affidavit where, my lord, we have annexed that order of demerger. That's the only reason, my lord, I had prayed for that leave. Now, this, my lord, now kindly take up page 44, because the rest of the petition, my lord, it's rife with judgments, which, my lord, I do not intend to trouble your lordship at all with. Kindly take up the order which starts from page 42. This is the assessment order of Gonkari Coal Mining Limited from page 42. Very short point, my lord. Page 43, I'll kindly give me 2 more minutes, my lord. Lordship. Red with 199. That's my case of the income tax. 1192B, after the circular of 2019, circular 9 of 2015, states if there is an, my lord, I have that circular, but before that, my lord, may I only indicate the order's operative portion, because that will make my case easier, my lord. But this has been passed by the National Faceless Assessment Center. This is passed by, my lord, the Commissioner of Income Tax, PCIT, Kolkata. Below 50 lakhs. Total amount is, my lord, 25,76,000 that we are, my lord, claiming. There are 4 years involved, 2016, 17, 18, 19, 20, 21, and 21, 22. It sums up to this figure of 25,76,921. And the difficulty is, my lord, this hardship I'll indicate is not our fault. And the moment it is a hardship, undue hardship, which is not imputed on the petitioner, 119(2)(b) comes into operation. I'll indicate that through judgments and through the provision. My case is not only on, my lord, a point of condonation of delay. That's not my case. Kindly take up page 40, my lord. That will make my, perhaps, my lord, my submissions more pointed. My lord, but I'll come to that application. It's from page 81 onwards. The first one is, my lord, page 62. That's for the first year. Second year is page 81. Third year 99. Fourth year 113. May I start with 62, my lord? Petition for condonation of delay under 1192B for delayed claim of refund of 7,16,000. Total claim of refund for those 4 years comes to, my lord, 25 lakhs. 76,921. But this step which is taken by the respondents is against the stand taken by the respondents at page 42. So, my lord, kindly take up 42 once. 42, my lord, is by the National Faceless Assessment Center. It's an assessment order. My lord, but with these are, my lord, the respondents, part of the respondents. The order says that the reason, my lord, kindly take up once, page 42. I'll indicate the reason. Why, my lord, I'm insisting on this order. Page 42, kindly, I only refer to... No, my lord, the reason is this. Kindly appreciate this, my lord. The respondents are stating that we will not give you this refund. You are not entitled to this claim of TDS for all these 4 years, because primarily we are not sure who is supposed to get this, whether it is the joint venture entity or whether it is the petitioner. It is their statement in 42, page 42. The assessment order says that it has attained finality. They have not challenged this assessment order. This assessment order, kindly take up 3 paragraphs where they say the joint venture is not entitled to get this. Hence, there is no one. My lord, kindly see page 42, the assessment order starts. Kindly take up page 43, the 3rd paragraph. The 3rd paragraph at page 43. Undue hardship, my lord. 119(2)(b only to this, my lord, to the effect that today you cannot impute the blame on me. March 11, 2022 is when we first came to learn that we will not be getting this benefit. May, we filed this application on 18th of May. This application, my lord, I'll indicate the exact date. It is, kindly give me a moment, my lord. We came to learn, my lord, on 11th of March. It's paragraph 18 at page 13 of the petition. Kindly see, however, only while recently, my lord, this is page 13, the last paragraph, paragraph 18. 18, my lord, the last paragraph. Unfortunately, my lord, this is filled with decisions and quotations therefrom. Paragraph 18, my lord. However, only while recently completing the assessment for GCML, that's a joint venture entity, my lord, for the assessment years 14-15 and 15-16, 16-17 on March 11, 2022. It came to the knowledge of the petitioner that no credit has been allowed to the petitioner for TDS, benefit whereof is to be received by the SSE. And as such, there is no delay in filing the petition under 119(2)(b. Because, my lord, the reason is page 42. The reason is page 42. Kindly take up page 42 once. The reason is this. We had, my lord, always known that we will be getting this benefit because of the assessment order of the joint venture entity.
Page 42 order is 2022.
Indeed, my lord, that's my case. Page 42 order is 2022. Also, my lord, my application is 2022. Same. March, my lord, we came to know. Same year, May 18, we filed this. The statute says 6 months you have to dispose of this application. They waited for 2 years. It is not our fault. The respondents waited for 2 years beyond the period prescribed in the statute. Statute says 6 months. You have to dispose it of. My lord. My lord. My lord, we could not have. The reason is until and unless there is an assessment order which is passed, whereby, my lord, we know that we have been, my lord, left out, and the department has taken a view. My lord, it was always, my lord, the position taken by the petitioner that we are entitled to it because of the assessment order, where it says, yes, my lord, because the 26 As will be reflected. It is, my lord, 26 As would be given by the department. My lord, we can only claim it if, my lord, there's a reflection in 26 As. We were under the apprehension, my lord, the 26 As, the reflection will be made in our favor. It was not. Lordship, my lord. Lordship.
16, 17.
4 years, my lord. 16, 17, 18, 19, 20, 21, 2021, 22.
That is what you say, paragraph 18.
My lord, from the records, yes. Yes.
On your back, financial year 13, 14. So 14th of March, 31st of March, 2021.
My lord.
14th of March 2014, you were aware that there has been no deduction of because nothing is reflected in the 26. Everything is online.
The order is passed, my lord. Lordship, my lord. My lord, my lord. Indeed, indeed, lordship, indeed.
31st of March, Mr. Val, you are aware?
My lord.
There is no deduction.
Proceedings pending. Assessment order, my lord.
Deduction. No deposit in your favor. How can you have your seat? So
I'll answer, my
you
lord.
were aware that there was any refund, and there was any TDS, nor did you make any claim. You did not make any claim at all.
I'll answer, my lord. Lordship. Yes, yes, my lord.
Neither you are aware that there is any TDS deduction in your favor, nor from your account, nor any 2022 under assessment. From the assessment order, you come to learn from the first time that prior to you were not aware of the deduction. Now, how do you explain this whole thing?
Well, I will. I will. Kindly take up page 42, the first box. The first box, my lord. Kindly take up the serial number 4. Before that, serial number 2, name of the SSC, Gondkari Coal Mining Limited. That's the JV. Now, kindly take up serial number 4, assessment year 2014-15. Now, kindly take up, my lord, serial number 9. Order passed under section 147, read with 144B. Now, kindly take up serial number 10. Date of the order, 11th March 2022. This is the department, my lord, in a reassessment proceeding for the assessment year 14-15 in the year 2022. What do they find for the joint venture? Kindly take up page 43, the third paragraph. And this is the crux of, my lord. I'm trying to answer the query which has fallen from your lordship. Third paragraph, page 43, my lord. The SSC company claimed that as the fixed deposit amount was paid by Dhariwal Infrastructures, that's, my lord, the petitioner before your lordship, Private Limited, the interest income thereon should be treated in the hands of Dhariwal Infrastructures, and accordingly provision was made in the profit and loss account and balance sheet of Dhariwal Infrastructures. On verification of the same, it is noticed that Dhariwal Infrastructure is not disclosing that interest income of 25,99,208 in its profit and loss account. Accordingly, a further questionnaire was issued to the SSC company on 18/2/2020. Details are quoted. After the quotation, my lord, the next paragraph. Subsequently, draft assessment order along with show cause notice dated 2/3/2022 was issued to the SSC, intimating it the proposed addition as under. Now, kindly take up the next page. Kindly see page 44. This is, my lord, the fourth paragraph. In the instant case, This is a part of the submissions, my lord. In the instant case, right from the beginning, it was clear. It was a clear understanding between Gondkari and DIPL. Gondkari, my lord, is the JV and DIPL is the petitioner before your lordship. That all rights, including related interest on concerned fixed deposit of 2 crore 87 lakhs, that's the FDR, my lord, which we had given, belongs to DIPL, that's the petitioner before your lordship, only. And the above fact has been duly acknowledged by both the parties in their financials. It is therefore an income by overriding title and solely belongs to DIPL. That's, my lord, the petitioner before your lordship. Now kindly see the finding. This is the paragraph thereafter. The submission of the SSC is carefully considered and accepted. Submission is accepted in view of the fact that the assessment for the immediate preceding assessment here has also been completed after accepting the version of the SSC on the same grounds. This is my case. When I come to know of it in 2022, I have immediately applied. And I say this has caused me. Kindly take a paragraph. I was not. Kindly take a paragraph 17 at page 13 of the writ petition. Page 13, my lord. This is where, my lord, we have pleaded genuine hardship, because that's the very basis of, my lord, an application under 119(2)(b). Petitioner states, paragraph 17, my lord, and submits that the petitioner was under an impression that since the TDS amount is reflected in 26 AS of GCML, necessary credit will be allowed to the petitioner by the respondent. But because, my lord, no, we could not claim. No, my lord, the difficulty is, my lord, the difficulty is this. Lordship. My lord.
All these years, the account reflect.
We could have only claimed for it. Yes, my lord, kindly see our petition. Yes, my lord, kindly see our petition once. Kindly see the first petition at page 62. My lord, kindly take up the first petition at page 62. I'll try and indicate that. Page 62, my lord. 62, my lord. There are 4 different years, so 4 different applications. I'm referring to the first application. Page 62. Kindly see the date, my lord, 18th of May 2022. At the left-hand corner. This is written by Dhariwal Power. Page 62, my lord, annexure P2. This is, my lord, by the petitioner to the income tax authorities, the principal commissioner of income tax. This is dated 18th of May 2022, my lord. Top left-hand corner. Kindly see, my lord, paragraph 2. For allotment of coal block, the MOC required to submit a bank guarantee to the tune of 10.27 crores, to which the other 2 partners had banking arrangements in favor of the JV. DAPL provided exclusive funds of 2.8, that's petitioner, my lord, before your lordship, 2.87 crores to GCML for FDR in bank in the name of GCML as their proportionate share, so that bank guarantee can be obtained. Paragraph 3, I'm skipping, my lord. Paragraph 4. In the meantime, during the continuance of FDR, there was an interest income as below, on which TDS 2 was deducted by the bank, to which is also shown in the 26 AS form in the name of the JV, GCML. So it is reflected in the name of the JV. So I can't claim. It is reflected in the name of JV. I'll indicate, no, it's all there. That is why, no, because, my lord, there the JV then stated that it is not my income. JV then stated it is not my income, my lord. Lordship. I could not. My lord. Yes, I could not, my lord.
Not a different question.
Lordship.
No, that is the main question, that you did not claim this refund.
My lord.
Not claim this refund. Now, after the assessing officer said that you suppress this, now you say, no, I am entitled to this amount.
No, we have not suppressed anything. I'll indicate. Perhaps, my lord, I am not able to, my lord, convey the facts in a proper manner. Let me try again, my lord. It's absolutely my fault. May I try this? My lord, TDS is deducted in the name of the JV. The moment it is deducted in the name of the JV, my lord, I cannot claim it. I cannot. As an entity, being a part of the JV, I could not have made that claim. Although it was an arrangement between the partners of the JV, that the amount which I have given, 2.87, 2.88 crores, will always be treated as my investment, my income, which is generated from the interest component of that investment. The moment that arrangement existed, the JV then, my lord, contended that it is not my income, do not tax this in my name. The reflection in 26 at the very outset, my lord, that's the culmination, my lord, 2014-15, but it was pending, my lord, it was not decided by them. They had to decide it, they decided it in the assessment order in 2000, the respondents. The assessment order which I thus placed reliance on.
As you have to make your own case.
Well, I cannot make out I understand, my lord, what is falling from your lordship. My lord.
The respondents will see on that.
Lordship.
Your case, according to you, is the JV's income your income?
JV's income is not my income. That's my entire case.
Not your income. Then you are not entitled to this adjustment. Simple.
I am, my lord. That is my entire case. In fact, that is the reason, my lord, kindly allow me to read on. No, that is what has been held by them. That this amount has to be held as an income of the petitioner. Hence, my lord, TDS, they have not challenged that order. That order is in my favor. No, that is in my favor. Why will I challenge it, my lord? Because that order says that today this amount DIPL is entitled to. So, my lord, Dhariwal Power, that's the petitioner before your lordship, is entitled to this amount. Kindly take up, my lord, 2 more paragraphs at page 63. After, my lord, the box, kindly take up, my lord, paragraph 5A. The above mentioned interest on FDR. My lord, kindly see in the table, net of TDS is indicated, my lord, 64 lakhs. 5A, my lord, the above mentioned interest on FDR of 64 lakhs was remitted by the JV to GCML, JV company GCML to the SSE, DPAL. In the financial year 15-16, accordingly, the SSE credited in its account. But this is where, my lord, perhaps I'll try and answer your lordship's query. The SSE credited in its accounts against interest paid on capital expenditure. At that time, it was assumed that the credit for TDS will be allowed because we had allowed for this expenditure. At that time, it was assumed that the credit for TDS will be allowed in the assessment of the JV company. That's my answer, my lord. It was not allowed thereafter.
Not allowed that.
Hence, I'm entitled to. But, my lord, I do not have any other. Kindly take up 1119, my lord, to B. Because I do not have any other remedy. I do not have any other remedy, my lord. I will place, my lord, judgments on genuine hardship, which place, my lord, I am carrying, my lord, the judgments on genuine hardship, which will perhaps fortify my submissions. But before that, may I? My lord. Now I can claim. That's what, my lord, has been also pleaded in my petition under 119(2)(b), that I could not have made this claim. I was always under the impression that this will be credited in the name of, kindly see 5A. That's my answer to the query which has fallen from your lordship. My lord, page 63, 5A. Kindly read it, my lord. Kindly permit me to read it once. Lordship. Yes, page 42 onwards, my lord. That's the final assessment order. They have not challenged it. That's the final order, my lord. Of the JV, my lord. JV kind. I could not claim the moment JVs is, yes, my lord. And we were under the apprehension that the JV will be allowed this. Kindly see 5A. Then, my lord, my chance comes. Because then I have to get the credit of this. Otherwise, this, my lord, the entire case. Now, at this juncture, my lord, may I request your lordship to take up paragraph 9 and 10 of the petition. Perhaps this is the best, my lord, answer that I can think of. Kindly take up paragraph 9 and 10 that encapsulates my case at this juncture, my lord, at page 6. However, my lord, may I only read these 2 paragraphs?
Yes.
However, in the process, there occurred a major technical problem. The TDS Form 26As on interest from FDR were issued in the name of GCML. That's the JV, my lord. That's the JV.
The moment
But the
Mr. Bhatt,
income,
you say, the
my lord.
moment you say this next line, but
lord.
the income related to the petitioner, then you ought to have disclosed this in your returns. This income related to the petitioner. Where is your disclosure? Where is your return? Show me. You
Lord,
cannot.
the
Because
moment,
you cannot, because that is the explanation you have given.
But
You
I-
had only come to learn in the year 2022 that this is your income.
22 I had come to, my lord, it has always been our contention. It was not accepted by the respondents. Respondents accept this contention
You make
of
out a
ours.
case. Let us understand this. You make out a case in the petition, Mr. Bhatt.
My lord.
The case may be accepted by the court, may not be accepted by the
Indeed,
court.
indeed, my lord. Indeed.
You cannot depend on what judgment the court will give. You will make out a case thereafter.
It was not a
Your contention has to be pleaded.
my lord. My lord.
Likewise, since your contention is required to be pleaded, likewise, you have to claim in your return, this is your income. Where in the financial year, assessment year 2014-15, you have claimed this. You say, I could not have.
Grateful, my lord. I'm grateful. Kindly
Yes.
permit me to read these two paragraphs and then
Yes.
Lord, perhaps I'll be able to answer this question.
Yes.
However, in the process, there occurred a major technical problem. The TDS on interest from the FDR were issued in the name of GCML, but the income was related to the petitioner. GCML neither credited interest as their income nor claimed TDS in their ITR, and as such, Form 26As remained unclaimed. Now, the next paragraph, Lord, kindly permit me. Further, since all Form 26As were in the name of GCML, the petitioner was not able to claim the same, and as the same were not reflected in the portal in the name of the petitioner. In this process, the TDS could not be claimed for several years, being for assessment year 16-17, 18-19, 2021, 2020, 21-22, totaling to this figure. Now, my lord, 11. Since no credit for the aforesaid account was given either to GCML or the petitioner filed separate petitions. Now, this is the reason, my lord. The separate petitions were filed under 119
Mr.
2B.
I understand this. Mr. You see, one major difficulty you are facing here. According to you,
my lord,
GCML, that is the
joint venture,
did not claim this TDS in the year 2014.
But it was credited in their name.
Did not claim it. Once they did not claim this, you are aware of this because you are part of the joint venture.
Yes, my lord. Yes.
So you are aware of this.
Yes.
Once you are aware of this, where is your explanation that why did you not claim then that they have not claimed it? So show it
Because
in my income.
I'll indicate. My answer lies in page 42 and 43, 44, which I just read. I'll indicate why. I'll indicate why. No, I'll indicate why, my lord. Being a part of the JV, it has always been the contention that this amount does not belong to JV.
Any
it belongs to the
authorities,
petition.
I'll be very candid with you, Mr. Bhatt.
My lord.
I'm not convinced with this part of the argument. But I understand that there is some difficulty. You may be suffering some at some point of time, but this is not the way out. So show me any authorities on this. If
May
you
I,
show me.
May I?
But
come back?
I'm not convinced with
I
your
understand,
argument
my lord.
so far as this part is concerned, Mr. Bhatt. But you see, 2014-15, Mr. Bhatt, you did not claim this as your income. You cannot say that you have become wiser on the basis of an order passed by the authorities in the year 2020-22 that this is your income. You can't say that. It's very difficult for the court to accept it and pass an order.
My lord, may I
Yes.
try and do this?
Show me
May I
any authority.
kindly permit me, my lord, to come back because I'll have the reason is this, my lord. I'll indicate to my learned friends also, my lord, for their convenience. I'll rely on a bunch, my lord, compilation of judgments, very few judgments, my lord.
Don't show me all the judgments.
No, only 2 or 3 judgments, my lord, which are absolutely relevant on the point with the propositions. And my lord, then I leave it to you,
on
lordship.
this point, Mr. Bhatt,
My lord.
that there cannot be unjust enrichment.
No, they can't. In fact, I have judgments on that point. There can't be an unjust enrichment, my lord.
But at the same time, you can you blow hot and cold? Can you say this is not my income, and thereafter you all on a sudden you say this part you have to explain?
Perhaps I'll try and, my lord, canvass my submissions to convince your lordship that the crystallization,
Give me a
crystallization of rights, my lord.
Rai, give us a glimpse of what you want to say on this.
My lord, very small. My lord, my submission would be very, very small. My lord, it's rather a repetition of the last 4 lines, my lord, of the order which has been impugned.
Yes.
My lord, that it is a case of correction of the TDS return. You correct it. My lord, insert the
There is a procedure.
Yes, insert the name of the SSE, get it refunded. My lord, how on earth, my lord, will this be possible? My lord, we have not filled the TDS return form. Bank is the deductor. Bank fills it, my lord, in the name of one company. I'll, my lord, change it and, my lord, give it to somebody else on the basis
What
of
about
an
this?
assessment order.
He's not claiming any income there.
That is why, my lord, let him, my lord. I don't know what is the understanding between him and Godkari, my lord, at one point in the assessment proceedings.
Those documents have not been disclosed also.
No.
It's all there in the assessment order. It's all
Well,
reflected
there
in the assessment order.
My lord, the 26AS form is also on record. 26AS form is not filled by the respondents. My lord, it has been filled by the deductor. My lord, the deductor fills it at the my lord, instance of the SSE. SSE says that it is to be deducted
14, 15.
in the name of.
No, wait, 14, 15, 16, 17, 18, 18. Six years is over. 119 cannot take benefit. Maximum period is 6 years.
Yes. That is why they say, my lord, it's not a case of condonation of delay. Why are you pursuing this? You kindly go and change your
And so far as rectification, I want to know from you, Mr. Rai.
My lord.
Rectification, there is a time period for rectification.
Lord, should be, my lord. I'll.
Same, this 119 will apply. Other provisions also.
Rectification, my lord, is under 154. So if we go by that,
No, that is not
that is the rectification of your return.
of the returns.
Yes.
No, he's on a different issue.
Yes,
Rectification.
kindly, my lord, page 131, paragraph 8. This is one of the orders. Paragraph 8, my lord, says that.
131.
Yes, my lord, I'm showing one of the orders.
The
my lord, there are
second order, my lord, for the assessment year 2020, 2021.
First order also, my lord, paragraph 8, it is clear
Similar
case
orders.
of rectification of TDS return.
Yes, under what provision that is permissible?
My lord, that I will also have to check up and, my lord,
Then
I'll-
check up and come back. Under what provision it is permissible?
Yes.
Also, my lord, may I only indicate?
You say that, then you are not taking a stand that he is left high and dry.
But we will not. If he's
correct.
entitled,
Now,
he's
if
not
you take that stand, this may not be the correct way out. But what shall be the correct way? You indicate there cannot be a wrong without a remedy.
Correct.
This may not be the remedy. I also accept that. But his difficulty, major difficulty is somewhere else.
Yes.
The major difficulty
is there.
that he has to explain.
Yes,
There is no
yes.
explanation.
No
in this
explanation.
petition.
No
Because in
explanation.
fact, these are conflicting
My lord,
paragraphs. 9, 10, and then come to which he showed just now, page number 13. These are all conflicting. Paragraph 18.
The query which
9, 10, then you come to 17, 18, conflicting.
Lord, the query which fell from my lord's lips, that my lord, as to whether this has been claimed as a refund in his return.
Has to.
That is, yes, it's important.
Not that he has to rectify.
Yes.
Otherwise, he cannot be entitled to this.
It's like,
Lord,
Lord,
I understand what you're calling from
Cascading
your
effect. Mr. Bagh, it is not that easy.
It's not, my lord.
Absolutely.
The
You cannot
submission.
be entitled to this refund straight away. For the refund, Mr. Bagh, you have to claim that. Someone has to claim. You cannot say that the order is there, therefore I am entitled to this. No.
My case is not that, my lord. My case would be in the assessment order. It has been accepted by the department on one hand that the joint venture, this is not.
I understand that.
So
That
someone
part
else
is there.
has
So
not
that's
taken-
why I'm asking. Come back tomorrow, Mr. Rai, on this,
Lord,
on the
instead of
provision, on the
tomorrow,
provision.
Yes.
Only on the come back tomorrow or day after, whichever.
Day after.
Day after. এটাকে রাখো তো। Day after.
But may I pray for one more day's accommodation? my
No,
lord?
no, you come back. Let us see.
Very well.
Let him come back. Day after tomorrow.
Day after tomorrow.
Just. The only issue is his difficulties. I'll test him out later. But since you say that this is not the correct provision, which is the correct? Is it possible? Where is the provision by which this has been corrected?
Whether yes, that can be done.
And if it can, ordinary correction will not do. He has to rectify his returns also.
Definitely. That is more
Has
important.
to.
That is more
Unless he rectifies his returns, he cannot get the benefit of TDS.
No, definitely not.
And for that, what is the maximum outer period? It's part by limitation, fair enough. But 119 only provides for condonation. If the application may not be in a correct form. See,
In fact, I'm only limited to, my lord, 119 2B.
No, 119
2B, my lord. 2B
definitely may not
says
be in a correct form, but that, my lord, then that has to be, there has to be a prayer for rectification in that case. If
Yes.
not, I say that 119B applies to that and not
Correct, correct, correct.
Then Lord, the prayer has to be to allow me to rectify, and Lord, he rectifies and then takes it in the usual course. If that is permissible, Lord, I shall come.
Then I can consider that prayer. I can consider.
Yes.
But whether it is permissible to rectify at this stage.
Yes.
Since you do not take a stand at this that.
Lord, I have been, my Lord, here unbiased. I have said,
seen
Lord,
that,
that yes, that it's a case of rectification. Now, whether that rectification is permissible or not, I have not tested that because I was not called upon to. I have said that this is not a case, my Lord, which falls under section 119.
I'm trying to discuss it now, that whether the petitioner can be entitled to this refund without claiming it.
Yes.
I have to test out that.
Yes.
Without claiming that, if he is not entitled to, then I cannot grant him any relief.
Because
you appreciate the situation.
I understand, Lord. I will.
That is what is troubling the court. Because unless you can demonstrate without claiming that refund.
In fact, Lord, in income tax, I can show that, my Lord, there are these provisions as well as, my Lord, there are judgments which say for refund, no separate claim is required to be made.
My Lord,
No, in
this
the
is-
return, in the
this is,
return.
my Lord, this is, my Lord.
In the return.
My Lord, if it is
not necessary
to assessing, no, my Lord, I'll have to check that part. I should
My Lord,
not
this
make that
again, my
submission.
Lord, probably, my Lord, 26A form may provide an answer. My Lord, the form itself, my Lord, shows as to who is the person in whose account the refund is to be credited. It is the assessee, my Lord, in whose name the tax has been deducted.
So there are
Therefore, my
two
Lord,
rectifications we have to consider.
26.
126, the form itself has to be rectified.
Yes.
And the second is, he is saying that not necessary to ask for that.
Lord, the 26A form is on the basis of the return, Lord, filed by the deductor.
Correct.
If I deduct.
So
Lord,
yes,
that has to
so
be-
the deductor's return has to be corrected
Yes.
also.
Yes. My Lord, the deductor,
It's a
unless the
cascading
deductor
effect.
files
It
the
is
return,
not
Lord,
that
how will
easy,
that be
Mr.
uploaded?
Bug, just you come
No, I
forward
understand,
and
my Lord.
get an application allowed. No.
Perhaps, my Lord, if I can show
My Lord,
that
there
there's
should have
separate,
been an arrangement between the JV and the deductor, my Lord, to this effect then. My Lord, if
that arrangement has been accepted by the department as reflected in the order.
A deductor has deducted this.
Yes.
While deducting it, he has disclosed his 10.
My Lord.
Now, he has also disclosed in whose favor he is deducting this.
Not sure.
There the correction is required to be made also.
It should be, my Lord.
So there is
the-
cascading effect, sir. You
20
can't today just seek one direction and get this money out.
No, I understand that, my Lord. Perhaps what is troubling me, my Lord, which I'll try and, my Lord, come back with an
I agree
answer.
on this, but first of all, let Mr. Rai demonstrate before this court what are the provisions. I want to see what are the provisions and then what are the limitations on this. What are the limitations also? Because today, limitation date, it will date back to the date of making the application, certainly, not of this date.
My Lord.
But still, then what are the limitations?
Correct.
May not be informed, but still then, what are the limitations? If limitation is such that it is not permissible, then he's out.
Then in that case, my Lord, that's a different.
But if on the date of making the application, if it was permissible, then ABCD, I have to certain this. Come back day after tomorrow.
Fine.
We will, my Lord. Great. Very deeply obliged. my Lord.
Your Lordship, I'm appearing for petitioner, Your Lordship. Your Lordship, the main counsel is not present before Your Lordship due to some personal emergencies. But in the last date of hearing, Your Lordship asked the petitioner to seek the instructions on 20% payment of the demand. Your Lordship, we are not in a position to pay the 20%. Your Lordship.
The application, madam.
Your Lordship, I'm not able to hear you, Lordship.
Last occasion, Mr. Rai, you have disclosed, where is that document? Kagozta দাও সঙ্গে আরো আছে. Yes. This is the CBDT circular.
Yes, all the circulars are there.
Yes, this is section 20, subsection 6.
220.
Which is the last one?
The last one is at the end.
Have you gone through this, madam?
Yes, Your Lordship. Your Lordship, I would also make a submission, Your Lordship, that Your Lordship, it is not mandatory to pay 20%, Your Lordship. And we have place the
third page of the bunch. My lord, it was hyped from, my lord, 15 to 20. My lord,
Where is that?
my lord, the penultimate paragraph, last 3 lines. Thus, all references to 15% of the disputed
That is
demand.
different issue. Where is the reference made to 15% first?
My lord, first page.
Acha, in order to streamline.
A.
Yes, yes.
Yes.
Unless the case falls in category B.
Yes.
Now, what are category B?
Lord, in a situation where the assessing officer is of the view that the nature of addition resulting in the disputed demand is such that payment of a lump sum amount higher than 15% is warranted. Lord, this is not the case. Higher than 15%. Lord. Next is the assessing officer is of the view that the nature of addition resulting in the disputed demand is such that payment of a lump sum amount lower than 15% is warranted. Example, in a case where addition on the same issue has been deleted by appellate authorities in earlier years, or decision of the Supreme Court or jurisdictional high court is in favor of the assessee, the assessing officer shall refer the matter to the administrative principal CIT or CIT, who, after considering all relevant facts, shall decide the quantum or proportion of demand to be paid by the assessee as lump sum payment for granting a stay of the balance demand. In a case,
so there is a discretion.
There is a discretion.
Very well. So it is not that 50% same. The old previously it was, as far as I recall, it was if it is disputed or any appeal has been filed, then he shall be treated as not in default. 220 subsection 6.
Yes. That is, my lord, the language, and in fact, my lord, the CBDT circular has also said that instead of stay of demand, kindly use the word.
Cannot stay. Stay will be given by the appellate authority.
Yes, that
Its
is
language 220 subsection 6 says so.
Yes,
To
yes,
be treated as not in default.
That has been clarified that the expression should be used not in default.
Justice Pal's judgment was very clear on this.
Yes, yes.
Mr. Pal's judgment. Yes, so what is their case?
My lord, they want to pay, my lord, they have paid 5 lakh. And
what is their case? Let me find out their case.
Kindly see their application. Their application is at page 41.
No, what are they challenging? Assessment order?
Lord, assessment order they have challenged in appeal.
Yes,
Now,
what
they
is
want
the
a stay
assessment
of
order?
demand.
Assessment order, what is the
Assessment
assessment?
order, my lord, is at page. The lordship will find that at page.
Educational Research and Development Foundation.
Yes, assessment order is at page 30.
What are they engaged in? What is the nature of?
My lord, they have a lot of institutions, my lord, running under them. That is what they have disclosed in their application, my lord. If your lordship sees the application, my lord, page 41.
And what is the demand?
Lord, the demand is at page 32. Assessed income, your lordship will find. On the assessed income, my lord, there will be taxes.
No, in notice under section 156 is there.
156 notice.
Penalty is also there.
Yes, that's there. 156 notice is there, my lord.
Yes, madam. Where is notice under section 156?
34, page 34, my lord. 8 crore 41 lakh 78,180 is the demand.
So 20% of this is how much?
20% of this, my lord, will 1.6 crore.
What is the defense? Why they don't want?
If you lord page 41, that is the defense. Page 41 is the petition for stay of demand.
No. Yes. What is
that is the petition, my lord. My lord, paragraph 2 at page 41. We are hopeful of substantial relief in the appeal, and levying tax as per notice of demand will cause undue financial hardship. The total assessed income is given rupees such and such, is a trust and running several institutions under its umbrella. The trust has following institutions running under it: University of Science and Technology, Meghalaya, thereafter Regional Institute of Science and Technology, Central Public School, Pathakandi, Central Public School, Badarpur, and several other small institutes. These are the institutions, my lord, that are run by, my lord, the SSE.
Now, is there any provision that the appeal shall not be disposed of unless this
No, there is no provision that the appeal shall not be disposed of, but my lord, the assessee will not be treated as one not in default. Therefore, my lord, we will be initiating proceedings, my lord, for recovery if the demand is not stayed, my lord, or they can not pray for stay
Yes,
before the
madam.
appellate authority.
No, that I will do. I will direct you to hear out the appeal and direct them to put in some money. Discretionary is a discretion is there.
Yes.
Yes, madam. What is your defense?
Your Lordship, we are not willing to pay the 20%, but Your Lordship, we can pay some lump sum amount, which is less than 20%. And Your Lordship, as Your Lordship has said, we'll move.
% of the amount?
Sorry, Your Lordship, I'm not able to hear you.
10% of the amount, madam.
Much obliged, Your Lordship, it will be okay.
Institution, I'm directing them.
Your Lordship, I don't have a clear instruction on this, Your Lordship. If Your Lordship would.
Otherwise, I'll not direct this.
Sorry, Your Lordship?
Between 10 and 15%, madam, tomorrow.
Okay, Lordship. Highly obliged, Your Lordship.
You would have got it today. I do not know what will happen tomorrow. Yes, madam. You are there. Do you have instructions? Diggi, file to
Your Lordship, Miss Priyanka Das is junior.
Do you have instruction in this matter?
No instruction. I was told that Miss Das is
If
junior.
if Your Lordship would grant some time, Your Lordship, just grant a passover. I'll come in. I'll
Less
come
than
in 15.
50% tomorrow. So tomorrow is another date. Today was another date.
Sorry, Your Lordship, if Your Lordship will give me 15 minutes, I'll come back with the instruction, clear instruction on this, Your Lordship.
Yes.
Number 5.
Your Lordship, so the matter is placed for tomorrow.
But we have drafted the opinion of affirmed the opinion of opposition, my lord. And
Yes, Mr. Chakraborty.
we have mailed to the advocate record on Friday, last Friday, my lord. A copy of the advance copy of the opinion of opposition was mailed, my lord, to the advocate of the.
Do you want to do it today or no, Mr. Watt?
Yes, I am
Tell
ready.
me, sir.
I am ready.
If you do not want to do it today, I'll place it on another date.
Yeah, I am ready, my lord. A copy I am giving to him subsequently.
There was an understanding before your lordship just before the vacation that he will be using an affidavit. He was keen to. Your lordship allowed.
Handover.
Understanding was that he will be providing
Advance copy, yes.
and so that I can get ready. Today, his advocate on record is saying that he has mailed it on Friday to my advocate on record. But we had that much of communication that Mr. Bhattacharya could have informed me at least.
It was, my lord, we have mailed it to his advocate record, my lord.
No, my lord.
What
This much of communication was required at the understanding that was in the court that Mr. Bhattacharya will communicate me.
Communication, you must receive the copy. Advance copy has been given to you. To your
Final disposal when you want it. No, opposition is there. You file reply.
The difficulty is this that my client is at stake. Goods are standing till date.
Next week, file reply.
Monday.
Yes.
Next Monday.
I need to file another supplementary opposition, my lord.
No.
Because I have got the report. I have got the report from the FASI. I have got the report from the FASI. That is not included here.
Whatever you want to come back. Produce records. I will see the records.
Yes.
Bring the records. I will see. If you are opposition, where is the opposition? Affidavit in opposition filed in court today is taken on record. Full stop. Reply thereto, if any, be filed on or before the matter is taken up next. Place this matter for further consideration on the same heading. Monday. On Monday next. On Monday. Date diye do. Monday.
Well, is keeping it on 18.
You want it Monday noy. Monday to বন্ধ আছে বোধহয়।
Yes.
ছুটি আছে। বলছি তো তাই।
17th is holiday, man. 17th is
holiday.
Tuesday করে দাও। এই কাউকে ডাকো তো লিস্ট পড়ে গেছে।
Keep it on 18.
No, no, my lord, 18th, I have got a fixed matter at 2 p.m. But my lord, kindly.
Is a difficulty.
After 3
No, no,
p.m.
it will continue. 2 p.m. It will continue.
If
for
you are not there, we'll
My lord, Mr.
if you are not there, I will grant you adjournment till next date.
Let the matter be there.
Kindly give me a liberty, my lord, to bring the, my lord.
You record whatever you will produce, Mr. Bhattacharya. Have I denied ever the records? Bring the records. But unless that record copy is shown to him in advance, I will not take into consideration.
I am kindly record in a copy I am giving.
I do not know. I am not granting you leave to file any affidavit. You show it to him in advance.
Well, he affirmed this affidavit today. So what prevented him to add those
If he wants to rely on anything else, go through this.
Will give me
Hand over today itself.
The next day he will again come and again another affidavit.
পড়ে আছে একটা কাগজ উড়ে গেছে দাও ডাকো পয়েন্ট দাও
Item number 6. Published. But has kept it on 18th.
এই যে আগের মামলাটা এডুকেশনাল সোসাইটি ওই সার্কুলারটা আছে
আচ্ছা ঠিক আছে
Yes.
I will explain.
Nobody is there. Very well. Since the petitioner is not represented, let this matter stand adjourned and appear in the monthly list of July 2020. আগের দিনও ছিল না আগের দিনও টাইম চেয়েছিল জুলাই করবে
Item number 7. In this matter, I am for the petitioner. My counsel is from Mumbai. Last time, your lawyer pleased to direct us up to file a supplementary affidavit. But during the vacancy, I could not affirm it, my lord.
Counsel is from?
Mumbai. Lawyer directed him to file a supplementary. That is
I
ready.
heard this matter, I remember.
Yes. But can you take him next Tuesday?
Short point.
Next Tuesday, my lord.
Yes. Next Tuesday. Date the
18, WW.
Next Tuesday, it may not be taken up, sir. Wait, Thursday করে দাও এটাকে দুটো মামলা আছে
They will be coming from.
That is why I'm saying next Tuesday it may not be taken up. Those two matters are there.
Okay.
Thursday I'm keeping it, so it will be easier for you. It will be at the top.
Yes, WW.
Because you'll be traveling from.
It means Thursday week, not
Thursday.
this Thursday.
No.
Yes.
Thursday
Not
week.
Thursday week.
Thursday week.
WW.
Chances are it will be a better chance to reach.
Yes. WW.
20th.
এটাকে remind me on that day he's from outstation, so I'll take up the matter.
Yes. I shall remind the lordship.
Item number 8.
As I am for the petitioner, my lord. Whereas on the last occasion, my lord has, in this matter, my lord has recalled its order.
What is the matter? You tell me.
This is with regard to the 148 notice that has been issued to the non-existing company, the amalgamating company, my lords.
Are where is the scheme?
The appointed date was
Show me appointed date.
My lords, may I file
I
the
had
supplementary?
practically passed the order. Thereafter, I had to recall it.
My lords, the appointed date was changed by the affidavit before the honorable court, and the honorable court has.
Sir, you should have indicated this.
My lords, in the order itself, it has been recorded that the appointed date is 1st April 2023.
Yes, then
Lords, may kindly come to the order.
The order is in respect of which year? Assessment year?
Assessment year 17-18, my lords.
Then,
however, my lords, the notice that has been issued is after the appointed date, my lords. My lords, I'm covered by my lord's own order, my lords.
No. Show me the order. Yes. No.
Completely same facts, my lords.
No, absolutely not.
My lords, if in this order itself, 17.
You come to page 44.
My lords.
Come to page 44 of your petition.
My lords.
All deaths Liabilities, duties, obligations of the transferor company be transferred from the appointed date
My lords.
to the transferee company from the appointed date. It does not cover the prior period.
My lords, my humble submissions are, my lords, if the company is non-existent.
No, it does not become really non-existent.
My lords, from the date of appointed date, 1st
Yes.
April 2023.
From the appointed date,
it
yes.
becomes
But the previous liability remains.
My lord, that has to be carried by the transferee company. That is what my submissions are. And in this order also, where my lords have recorded this particular thing, that the whatever the debts, liabilities, or tax liabilities whatsoever, that will be carried by the transferee company. Unless we do not have any obligation that the same may be carried by the transferee.
So the notice will not fail in that case.
My lords, the notice will fail.
Not fail.
My lords, to the transferor company, it will fail.
I
My
will
lords.
provide. This will be deemed to be a notice to the transferee company.
My lords, this particular notice is non-honest. My lord, this is the settled principles of law, my lord.
Sir, this is no longer non-honest in light of this appointed date. In light of the appointed date is not honest.
They may proceed as per law that they can issue.
No, I will not. No, I will not set it aside.
My lords, in this
That is
matter
the reason
also,
I dictated this order in your presence.
My lords,
and you did not point out
this appointed date, my lords, is recorded in the order and it is annexed. It is a part of my writ petition, my lords. My lords, at that point of time,
and the appointed date was changed.
My lords, this appointed date. If my lords may kindly come to page number 43.
Page number 40, I have seen that. All this you did not point out.
1st April 2023 is the appointed
Both of
date,
you.
my lords.
But where is the scheme? Where was the scheme?
Both of you,
The
you also
scheme-
did not point out,
The
sir.
scheme
Mr.
came
Sir.
later on, after your lordship asked for it.
My humble submissions are first
Scheme
April.
copy dao. Scheme copy dao.
Scheme copy.
You have copy of the scheme.
I have.
Show me from the scheme.
Well,
Who is to take responsibility?
Take page 2. Clause 8. Page 2, clause 8.
This has been changed, my lords. Before the Honorable NCLT, we have filed a affidavit. If my lords want, my lords, I will file the supplementary affidavit to that effect, my lords.
Now, appointed date of the transfer date. This was?
1st April 2016.
Yes. Now, this has changed
Yeah.
from 1st April 2016 to 1st April 2023.
Yes.
My lords.
If
1st
that
April
is so, 2023,
my lords.
the prior liability is with the transferor company.
Transferor company now, my lords, 1st April 2023, the transferor company becomes non-existent, my lords. And thereafter, any notice whatsoever, if there is anything that has to be.
Wait. Sir, wait, sir. Paragraph number 9, rejoinder, kindly read. Has obtained copy of the no objection in annexure G. Kindly see the date of no objection from Income Tax Authority.
My lords. And this is which page, my lords?
43.
43.
Of the order. Where is the entire order? Where are these annexures?
My lords, if my lords want,
Where are these
I
annexures?
can file the annexures, my lords.
Why have you not filed it? Why is I'll impose cost on you now, sir?
My lords, I'll file through supplementary affidavit. Unnecessary, my lords. I do not want it.
Why?
Because the same was.
Why do you consider this is unnecessary?
My lords, no objection certificate has been enclosed. It is in separate annexure, my lords.
My
lords, I'll show them.
If you have obtained this order by suppressing this, the order becomes bad.
My lords, kindly come to page number.
I'm not going to allow this. You see, today you obtained a no objection from the Income Tax Authority.
My lords, page number 32, my no objection certificate is enclosed. My
yes, show me that.
Page number 32 of my writ petition.
Make observations in this case. Yes, when was this?
My lords, this is on 13th March 2020. They have given the no objection, my lords. They were knowing this particular scheme. Now, my lords, 1st April.
They were aware at that stage that the appointed date is 2016.
My lords, they were
So
party to
your
the
fresh
proceedings.
no
My lords.
objection was necessary.
We have filed a reply, and the order we have received on
Everything
11th.
will get frustrated, sir.
My lords,
Because you did not intimate the income tax authority of the change of date.
my lords, it has been intimated, my lords. 11th
show
March,
me.
they were party to the proceedings, my lords.
No,
Page number
sir,
33,
nobody
my
goes there. Once a no objection is issued, everything is over. Page 32, once it is issued, everything is over. Page 32 is issued in the year 2020.
Page number 33, my lords, the final order, 11th March.
13th of March 2020.
13th of March.
Prior to the pandemic, they issued the certificate.
They have issued the certificate, my lords, no objection certificate.
Correct?
My lords.
And they were aware at that point of time that the effective date in the scheme is March 2016.
My lords. My lords.
Now, thereafter, you change that date.
My lords.
So this no objection becomes invalid.
My lords, even if that is so, my lords, if let's say suppose if the appointed that
Send it
date
back to
that
the
they were aware,
company law tribunal in that case.
my lords, if my lords, I have given an affidavit to that effect.
Show
They
me
were
where
party
is your
to the
affidavit?
My lords,
Where is your affidavit?
I will file the same through my
Yes,
supplementary.
bring in all these documents.
Kindly allow me
Sir,
to
this
file
is not you opt-in and no objection from income tax authorities. Thereafter, you change the appointed date without informing the income tax authorities. Sir, are you aware with regard to this?
No. Millard, kindly see that no objection is regarding the proposed scheme of amalgamation.
Correct. Scheme, everything is included, sir. In the scheme, Mr. Dot, everything is included. Everything under the sun. Now, in the scheme, the effective date is 2016.
Okay. 2016, in the application it is 2016.
Correct.
But the order passing the scheme.
So they alter it subsequently by way of an affidavit.
We had taken instructions and honorable court, we had filed an affidavit to that effect, and it is a court order that the appointed date is 1st April 2023, my lords. It is
correct. Now, while passing the order, was the court aware that the objection is limited to the year 2000, this is 13th of March 2020?
They were
Was any fresh objection obtained? No objection
if
obtained.
I have informed to the income tax authority.
Where have you informed with regard to the subsequent disclosure?
Kindly subsequent disclosure.
Naturally, when you have changed it, where is your affidavit? Have the affidavit
will
been served on the income tax authorities?
I have to check. I will
Check and
file
come
all
back.
the
Check and come back.
documents, my lord. I need some time, my lords, in that regard.
No, I will not give you time in this matter.
My lords,
This matter,
just
I'll not
now,
give
my
you
lords, today I called the petitioner.
Yes.
And I was
If the
informed that there
petitioner
is
has
a
suppressed things, then the petitioner will face
My
consequences.
lords, we have not suppressed anything, my lord. My lords, my humble submissions are, even if the date is 1st April 2023, then also the transferor company becomes non-existing company, and any notice to the non-existing. My lords, may kindly issue that the notice may be issued to transferee company.
No, sir. It's not that easy, sir. It is not that easy, sir.
In this matter also, in the order that my lords have passed.
Different, absolutely different matter.
My lords, the assessment year is 17-18.
Maybe.
And the appointment date is 1st April 2019, my lords.
Correct.
Thereafter, my lords, 1st April 2019, if my lords what.
Sir, try and understand the situation. 2019 is the appointed date. Now, after the appointed date, everything happened. The proceedings were there. Kindly see.
As in this
Notice
case also,
under section 148 AB was issued on, it was reopened. 148 AB. Case of reopening, sir.
My lord.
Try and understand.
My lords.
And in this case, the case of reopening is there.
We have received this.
When have we received that reopening notice?
148 AB notice has been received, my lord, on 8th of March 2024.
Correct,
my lords.
Now,
however, my lords,
8th of March 2020, is an order. No, where is the notice?
140.
Oh, this is the date of the order. 148 AD, notice under 148 AB. Where is the notice?
That is what I'm saying, my lords. Kindly come to page number 15, my lords.
Yes.
8th March 2024. This is the notice date, my lords. It is annexed to my petition, annexation number P2. And thereafter, they have passed an order
on 4th April 2024.
4th April 2024, my lords. Page number 18, my lords.
You show me your affidavit.
I will, my lords. I will file a supplementary affidavit to that.
Tomorrow.
Milord,
My lords,
kindly see one thing, Milord. At page 43 of the, which is part of the order, there is a mention of an affidavit. There is a mention of an affidavit. Kindly see, Milord, above paragraph 6, page 43, above paragraph 6, there is a paragraph. An affidavit dated 29 January 2024 has been filed for change in appointed date in the scheme from 1st April 2022 to 1st April 2023. But 1st April 2022 is nothing. Well, it was in 2016. The appointed date was.
So there are inconsistencies both in the scheme as also in the order.
Yes.
So unless I've seen that while correcting, these are the inconsistencies that were noted. You've seen the order 22nd May.
Yes.
Passed by this court.
Yes, my lord, I have.
So that is the reason why the scheme was not there. I had called for the scheme. I recalled my previous order. Tomorrow, file supplementary affidavit, disclosing the affidavit, everything.
my lords, kindly make it 1 week, my lords, because I'm just telling why, my lords. Today, when I called, the petitioner's aunt is actually expired, my lords. So they are outstation, my lords. I will need some time. My lords, may kindly.
Since an accommodation has been sought for, since the petitioner seeks for leave to file a supplementary affidavit to bring on record the affidavit. Formed on 29 January 2024. As referred to in the order dated 11th of March 2024. Let this matter stand adjourned and appear under the same heading on 19th of June 2024. List this matter accordingly. No, ये तो है 19 June में list और करनी. The notice under section 148 AB is dated when?
March 8th, 2024.
So prior to this order?
11th March, my lords. But my lords, 148 AD and 148 AD, 148 notice was on 4th April, my lords.
I'll consider this issue. So far as the judgment delivered in the case of this bull power suppliers, that is different.
As more plus merchants.
Yes, more plus and bull power suppliers, also known as primarily known as bull power suppliers. कुछ बोलना? Let this matter stand adjourned. Let such supplementary affidavit be filed on or before the matter is taken up next.
Your Lordship, in item number 4, Your Lordship, I'm unable to contact the petitioner, Your Lordship. Your Lordship, I'll be highly obliged if Your Lordship will accommodate the matter in tomorrow's list, Your Lordship.
There tomorrow. 20%.
Your Lordship, highly obliged.